Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, chairman of the board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, Paul Melnick, and Peter Owen. Also present is the professional staff, including Deputy Zoning Administrator Andrew Noxon, who serves as Secretary to the Board of Zoning Appeals, Arlova Vaughn, Acting Zoning Administrator, Christine Sanders, Assistant County Attorney, Clifton Hogan, Assistant to the Zoning Administrator, and Blake Bowen, Assistant to the Zoning Administrator. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you will find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen that report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or amend the regulations set forth in the ordinance. That authority rests with the county board. The board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of the decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purpose of the master plan and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the board must determine that the strict application of the ordinance would unreasonably restrict and produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and the character of the district will not be changed by the granting of the variance. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available in the front of the room, and give it to Mr. Bowen. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 5 minutes for applicants for use permits and variances, 3 minutes for representatives of organizations, and 2 minutes for individuals. For appeals, 20 minutes for the appellant, 3 minutes for representatives of organizations, and 2 minutes for individuals. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Thank you and good evening. Our first case tonight is V-1156-16-UP-1. This is a use permit request by Svetlana and Jeffrey Edmides to permit a setback of 2.8 feet to the pergola, 3.9 feet to the eaves of the new two-story addition and the new second-story addition, 5.4 feet to the wall of the new two-story addition from the right side property line instead of 8 feet as required, and 0.3 feet to the pergola and 3.7 feet to the eave of a new second-story addition from the left side property line instead of 10 feet as required. Also 20.8 feet to the pergola from the rear property line instead of 25 feet as required. Then an aggregate side yard of 3.1 feet instead of 18 feet as required. This is all for the construction of a new two-story right side addition, the eaves for a new second-story addition above the existing first floor walls. Also to maintain 2 existing pergolas, which are in the right and left side yards. This is in the R6 zoning district. The premise is known as 1805 North Madison Street.
Thank you. Questions for staff? Ms. Malice.
At our place was some information called supplementary information. Was this from you or from the applicant? Yeah.
These are from the applicants. Neighbor support letters.
And the pictures as well?
Correct.
Thank you.
Thank you. Can we hear from the applicant, please?
Is this the timer right here?
Yes.
Okay. Well, thank you, ladies and gentlemen of the board. We really appreciate you taking the time to review our case. My name is Jeffrey Edmides. I'm accompanied here by my wife, Svetlana, one of my children, and a few of our neighbors. I'd like to take the opportunity to thank the staff for shepherding us through the process. We had never done anything quite like this before, and they were very helpful in making sure that we checked every box and crossed every T. So we do appreciate the help. Our use permit application covers 2 broad requests. The first is for a renovation of our existing home. Our home was built in 1942. We love it. We've been living there for just over, I guess now, 10 years. We love the neighborhood, would love to stay in the neighborhood. We have, both of our children are growing up. My oldest is 11 and my youngest is 9. They share their room right now and they're very happy with that, but that may change over time. We anticipate it will change. And our house right now is a Cape Cod that has a relatively small upstairs and a quite divided downstairs area. We'd like to modernize it and allow the kids to have their own room upstairs with us. So the modifications to the home itself are designed with that essentially in mind. We wanted to keep the character of the house as much as we could, so we're not changing the footprint very much. It was very clear when we spoke to an architect that that's exactly what we wanted to do. We wanted it to look as much like the current house as we could manage without making it a giant house. Our lot is small by modern Arlington standards and is non-conforming all over the place. So when we try to do anything much, that requires a variance permission. So in the process of doing that, that's our goal for the home itself. So we just wish to modernize it, restructure that upper floor in a way that allows for 3 bedrooms up there and for us to stay in the neighborhood in the long term beyond when our kids leave home. The second request really relates to these 2 existing structures at the back of the house. I think you've seen some pictures in that supplemental piece, which are 2, we call them pergolas. Essentially, one is a deck with a trellis structure attached to it, and the second is designed as a cover for the grill, which we typically put a grill just up there on this area in the back patio and use this as a cover. We built the larger structure in 2012 with the intention of making a small portion of our yard, which had a more substantial slope on it, and we weren't able to use it for anything else. We wanted to make that area more usable, and we insisted that the contractor that we use go through all appropriate channels and get permits. He is a small businessman working on his own. It was the first time that he had gotten a permit through Arlington County. But he did. He pulled the permit. We got 3 inspections done of that larger structure, and all were passed, and it was approved. We had discussed this at length at the time with our neighbors, and they were and still are excited about the structure, and I have used it quite a bit since it's been built. And when we were considering the second structure, it was a companion piece that we thought aesthetically would match the main piece. And the reason we didn't apply for a permit for that was we felt that it was too small in terms of the surface area that it had covered to qualify as requiring a permit, which the contractor, which was the same individual, thought was also the case. During the current use permit process, we were informed that the larger pergola was built on a different spot than the contractor had indicated on the plat used when pulling the permit, partly, I think, because the plat used for drawing was an outdated one, which was 20 years old at the time. We're not sure why the plat was used. We didn't provide him with that one. And nonetheless, the result of this is that the structure is closer to the fence than the ordinance allows, requiring us to obtain a variance for it, which was a surprise. The staff recommendation is to allow renovations of the house structure but deny approval for the pergola structures. And we would request that the board reconsider this, as we acted in good faith while building it, are very restricted in building anything in our backyard due to the shape and size. It narrows towards the back, and have full support of the 3 neighbors who might be affected by the structures. We feel they contribute positively to the rear areas of all of our homes, and due to the natural slope of the land and height of the fence, it's not obtrusive. Retaining the pergolas, particularly the larger one, will not have a detrimental effect on neighboring properties, either aesthetically or in terms of value, and adds to the aesthetic value of the house and greatly enhances our utility of the rear end of the house. Thank you so much.
Thank you. Any questions for the applicant? Hearing none. I have 2 speaker slips. Robert Ryan.
Good evening. As I indicated, I appreciate this opportunity to address the board about this permit. My name is Robert Ryan. My wife is Nan Ryan. We live at 5919 North 18th Street, which is directly the opposite of the property under question. We've lived there for 51 years, and we'll probably be here when I go the other way. We would like to express our support for the renovation and improvement of the Ed Beats property. The plans fit nicely into the current neighborhood scheme and, in fact, should enhance the overall appearance of the neighborhood without the construction or renovation of the large houses that we now see being put up in Arlington County on very small lots. I also support and request the board to include the 2 I have trouble with that name, pergolas, in any improved variance and use permits. The pergolas are tasteful, they're hidden from the street, and add to the value of the property. We are not aware of any neighbors having a negative position on this particular variance. As my wife and I express our support for the total construction package, including your approval of the pergolas as they are currently located. Thank you.
Thank you. Eric McCabe.
Good evening. My name's Eric McCabe. This is my wife, Rose, and appreciate the opportunity to come up and speak to you. I live next door to Jeff and Sonny. Our yard is adjoining theirs. You can see it in the picture. It's the opposite side of that photograph. But it's come to our attention that the zoning board believes that the existing pergolas in their backyard may somehow affect us in our backyard. This pergola faces my backyard, and it in fact enhances our backyard. It's very nice, very green. We'd like to make it perfectly clear to the board that not only do the pergolas not negatively impact us, but on the contrary, They help us to enhance our neighborhood environmentally as well as beautification of the neighborhood. So making this simple, in conclusion, it is our opinion that enough energy has already been expended on this issue and recommend this board approve the Meads home improvement as originally presented and without exception. And I thank you for your time.
Thank you.
Any questions?
Any questions? Thank you.
Thank you.
It's with the board.
Madam Chair,
Ms. Malice.
question for staff. On the pergola question, the applicant indicated that it had been inspected 3 times by county staff. Is it typical that they verify the location when they do that inspection?
No, typically the inspections that they have for those sorts of structures are for structural or any trades that may be involved. There wouldn't be any trades involved with this. It would just be a building inspector. So they're not the ones who are going to measure the distance from the property line. If a zoning inspector were to go out there, or if a final plat was to be submitted showing that it was closer than either 8 or 10 feet to the side property line, then zoning would have held that up.
And as far as you know, that neither of those cases happened.
It probably wasn't required at the time for those structures.
Thank you.
Mr. Melnick,
I'd like to make a motion.
please.
All right. In case V1115616UP1, I'd like to make a motion that the Board of Zoning Appeals adopt the attached alternative resolution, which sets forth what was applied for as advertised with the conditions as stated.
Second.
It's moved by Mr. Melnick, seconded by Ms. Malice. Any discussion? Yes, Mr.
Just
Owen?
briefly, the left side pergola is the one that's sort of right almost over the property line. And to me, that would be the more disturbing, one from the standpoint of, is it consistent with the rest of what's in the neighborhood? But as the applicant pointed out in his presentation today, there is a considerable grade change there. And so the neighbor's backyard is up the hill considerably, even in that short distance. And to me, that's an important factor in approving this, just from my own perspective.
Thank you. Any other comments? All those in favor of the motion?
Aye.
Opposed? It's approved 5-0.
The next case is actually going to be a deferral. This is V-11157-16-UP-1. This is a use permit request by 3900 6th Street South LLC and Dan Lindsay to permit a setback of 15 feet to the eave and 17 feet to the porch base from the 6th Street South right-of-way instead of 21 feet as required. It's to maintain an existing front porch. This is in the R6 zoning district on the premises known as 3900 6th Street South. And the reasoning behind the deferral on this one is we found out that their front addition has not met the front yard setback when the wall check came in, so they have to come back for both issues, the front porch as well as the front addition.
Is there a recommendation on the date?
To defer to August 10th.
Thank you.
Madam Chairman,
Mr. Owen,
I move that we defer this item to the August 10th meeting.
could you read the case number, please?
I move that we defer V-11157-16-UP-1 to the August 10th BZA meeting.
Second.
Thank you. Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Next case, please.
The next case tonight is an appeal. This is V-11158-16-APP-1. This is an appeal by 3336 Wilson Boulevard LLC of a determination by the zoning administrator stating that the transitional parking lot located on North Kenmore Street shall not be used to satisfy required parking for a proposed development on the property located at 3336 Wilson Boulevard. It's in the C2 and also R6 zoning districts, and the premises are known as 3330 and 3336 Wilson Boulevard, and the adjacent parcel located on North Kenmore Street, which is not addressed.
Are there questions for the staff, the zoning administrator, or the county attorney?
Just,
Here-
Madam Chair,
I assume there may be later.
Madam Chair, just
Ms. Malice.
Just to clarify, in this initial approval, there were 2 actions. One was to approve the motel, and and it was a separate action to approve the transitional parking lot.
The use permit was to approve the transitional parking lot. The motel was by right.
Was by right. Okay. Thank you.
Thank you. Mr. Pritchard, welcome.
Good evening. Evan Pritchard with Walsh Colucci here on behalf of the applicant owner of both properties you see up there, the Highlander Motel and the adjoining transitional parking lot. I think mine's loaded. There we go.
Are we having
There we
a
are.
show and tell? Okay.
There we are. I want to start with this image just because, from my perspective, this is what this case is about. This is an aerial view. Sorry, it is out of focus of the transitional parking lot on the R6 lot. I'm going to go through this sequentially, and hopefully you'll agree that the facts themselves are fairly simple. The key issue here is the continued use of this transitional lot for a public parking lot, including customer use, to serve some adjacent commercial uses. As you all know, for the last 50 years plus, that commercial use has been the Highlander Motel. The use permit was approved in 1963. Since that time, the zoning ordinance has obviously changed a lot. In that time, the surrounding area has changed. Community needs have changed. The parking lot has been one of the near, if not totally constant, near constant throughout that entire time. So I'm going to go through some slides and highlight the fact that at the time of the use permit approval, there were no prohibitions on the use of this parking lot to provide required parking for those commercial uses, nor did the zoning ordinance in 1963 preclude that use. And as you may be aware, and I believe the zoning administrator pointed out in her report, it wasn't until 20 years later that became a prohibition in the zoning ordinance. I'm going to start with the building plan, showing that, as Ms. Vaughn mentioned, was approved by right, showing 45 spaces, all on the commercial lot. I'm going to demonstrate to you how that never actually was implemented, wasn't implemented in the 60s, never has been. You're going to see reasons why, including a pylon sign that was installed in the site in the 60s and still stands today. That there were parking spaces located in a manner that would preclude use of the adjacent lot. That was reconfigured so that right there you lost 8 spaces and didn't have all the spaces you needed on the commercial lot. And I'm going to go through how in the staff report at the time of the original approval, there is language in the staff report that recognized these constraints on the 2 sites and suggested that this was likely going to be the case. Finally, I'm going to walk you through the use permit approval and just highlight again, no conditions of the use permit spoke to parking. They were solely limited to screening and orienting the parking towards those commercial uses. And the language of the approval itself didn't place any restrictions on the nature of that commercial use or the specific commercial use off-site. So here is just an image of the original building permit that was mentioned, the by right building permit for the motel, 45 rooms, 1 per 1, 1 parking space required then and now per room, so 45 spaces to be provided on site. This is an image of the plan that Mr. Noxon kindly provided to me, showing how all 45 spaces are kind of crammed on this site. This would not meet today's standards at all in terms of lane width requirements. And if you kind of eyeball it, you can imagine getting a 1963 Chevelle or Cadillac in and out of this parking lot would have been a disaster. Here is a close-up image. I just added some red stop signs counting up all the parking spaces where all those 45 spaces existed. The 8 spaces you might have heard me mention at the beginning are in the upper right-hand corner. That is the boundary line between the commercial lot and the R6 lot. I also circled the word retaining wall because those building plans also envisioned a retaining wall right along that boundary, which you can imagine would also restrict movement between those two lots. And so that's sort of foreshadowing there. More foreshadowing is the sign permit that was approved shortly after those by right building plans were approved. This is September of '63 for a pylon sign you'll see later. And this is the use permit application, just citing that this is for additional parking. As originally written, you'll see it says additional parking in connection with the motel now being constructed on adjacent property. And then someone added at some point in handwriting a public parking area as a transitional use. Statement of justification submitted by the applicant, just again, additional parking, intent to provide better circulation of traffic for the area. This is the staff report that was issued at the time. I've just highlighted here a few things I want to point out. It's only the staff report from the 60s that makes any mention of required parking versus parking above the requirement. This is, in my legal opinion, dicta in the staff report. It wasn't codified by the board in adopting the ordinance. It wasn't injected into the two conditions that were mentioned earlier. But it notes the difficulty on the site in stating along this part of Wilson Boulevard the shallowness of the zoning district. Then as now, the C2 strip of zoning along Wilson is fairly shallow. And the staff report noted that additional depth should be made available for commercial uses and suggests that the use permit, or doesn't suggest, but states that a use permit for transitional parking would be a good compromise for an expansion that wouldn't be too invasive into the adjacent R6 development. And as mentioned here in the staff report, this is where it calls for only two items, heavy screening and that the access to the lot be oriented towards Wilson Boulevard and the existing commercial ground. And I note that it says existing commercial ground. It doesn't say oriented towards the motel that can forever after only be the use tied to this transitional parking lot. These are where I've put that X and highlighted there. Those are where the 8 spaces would have been had they continued, had they followed and continued to be present from the building plan that you saw earlier that was approved in September of '63. Here, this is by November of '63 when the board was considering this use permit. Those spaces have been taken off. You can't see them anymore for that reason. And you can see how there are a number of spaces shown in the R6 lot that are oriented to the north towards that commercial zone. And you can see on either side there's some drive aisle width so that you'd be able to access those in your car from the C2 lot. Here is the excerpt from the meeting minutes, which is the official ordinance approving the use permit. Again, just highlighting subject to screening approved by the county manager, access to the lot to be oriented towards Wilson Boulevard in the existing commercial ground, permit for transitional parking. This is an excerpt from the contemporaneous zoning ordinance, just definition of public parking area, open street area other than a private parking area used for parking of motor vehicles, available for general public use, including customer use. And then the snippet below that is from the zoning ordinance at the time, just stating what additional rules apply for transitional parking areas. And I included this here just to emphasize that there was no mention of required use being precluded. Again, that came into effect in 1983. So here it was in all its glory. We're guessing this was about 1967, pretty close to the original completion of the motel. You can see that sign I mentioned on the left-hand side. Another thing I should point out on this is you see that red car there. That red car is in a space. There's one space next to it. That's another difference from that 45-space plan that was approved. There were 3 spaces shown right there. That was very optimistic. That there are two spaces there in this photo in 1967, 2 spaces there today, and 2 on the other side of that raised walkway there. Just another picture. I like this version of the sign. I almost kind of wish this was the one that was out there today. Just got a little more spunk. This is the first aerial photo that we were able to find that post-dated the construction of the motel. Sorry for the lack of clarity, a little grainy, but I've tried to highlight the sign location and show you where the C2 lot sits relative to the R6 lot. Again, by 1969, you can already see pretty much the same configuration that's out there today. A little difficult to see all those cars, but about 20 cars or 20 parking spaces there, same as today. No 8 spaces up at the top, but clearly R6 lot, transitional lot, doing a lot of heavy lifting. Little bit better resolution on this photo from 5 years later, 1974. Again, you can make out now 20 spaces on the R6 lot, and it's difficult to tell, but there are 25 spaces up on the C2 lot, same as today. Get a little bit better image of that sign. I may not have said up till now that sign also was a way you could not have had those 45 spaces all on C2 lot. The C2 lot, you would have had to have some of your required parking from the get-go on the transitional lot. So this is the site today, bird's eye view. Total of 25 spaces on the C2 lot, 20 spaces on the R6 lot. I did not include it as part of my presentation. I do have it as a backup slide if you want to see it, but what we have talked with Ms. Baum and Mr. Noxon and Ms. Sanders about prior to today is what we want to do with the CVS, what we believe the required parking would be. It would, for the CVS, that CVS tells us is the bare bones minimum store that they're even interested in, the required parking would be a total of 18, excuse me, let me go to my slides so I don't mess that up. Total of 25 spaces required versus the 45 that are required for the motel use. And so the reason I'm pointing that out is that we would be able, the civil engineer who's looked at this and the plan we shared with staff indicates that 18 spaces could be provided with that CVS footprint on the C2 lot, so that an additional 7 spaces needed to meet the zoning ordinance requirement would be on the R6 transitional lot. So that would be a decrease of 13 spaces, down from 20 required spaces that have been there for 50 years down to 7. So piece of case law that's mentioned in the staff report that I saw late on Friday that I wanted to touch upon. Just wanted to distinguish that from the situation we're looking at here. As I mentioned at the beginning, the use that is at play here is that R6 transitional lot use. The use that was discussed and decided in the Goyanaga case that staff has cited involved a situation where some homeowners in Falls Church had a non-conforming home. It didn't meet their lot didn't meet the current lot requirements. They violated the current setback requirements, a number of other issues, coverage requirements. They obtained a variance for relief on the setback requirement. They were told by the zoning administrator when they wanted to do some renovations, you can do those, but be aware that under Falls Church's zoning ordinance, your non-conforming use is only going to be protected so long as at least 25% of the original structure remains intact. So they went ahead with a demolition plan, demolished less than 75% of the home. Building inspector came out, said these walls aren't safe, you need to take them down and replace them with sturdier new walls. Upon doing that, they in effect, this is not a photo of their home, by the way, they in effect demolished the entire structure, 100% gone. They were then told by the city and later the court, sorry, you can't build that house back. Great, you had a variance for relief from the setback, but you had all these other nonconformities. You no longer have any protection under the city code. That's a very different situation than what we have here. What I think is more relevant to the situation we're looking at, i.e. a use of land rather than the structure itself, is a case known as Knowlton. It's also a Virginia Supreme Court case. I'm happy to pass out copies for anybody who would like. Sure.
Find it on.
I apologize, I didn't have these prior to today. Oh, see, I thought ahead, and I brought them up here with me so I'd have them right at hand, and then I forgot about it.
Just
So as those are being passed around, I'll just give you the Cliff Notes version of that case. That involved a piece of land in a pretty rural area, historically a farm. I believe there was some hog raising there way back when, some farm trucks. And by the way, on the copies that are being passed around now, I underlined in blue the parts that I'm going to be focusing on of that decision. The farm was used for hog raising, and there were some incidental truck uses on there, according to the background in the case that the court set out. Historically, there are around 4 trucks being used on the site. Occasionally, they'd be worked on. I like how the opinion points out that they would be worked on under the shade of a tree. Over time, the operations on this piece of land changed significantly. It eventually morphed into basically a junkyard trash distribution site with either 17 or 18 trucks, large trucks being used on it, a large garage for vehicle servicing, and underground gas tanks. So the court ruled that whereas the prior use for farming and for commercial truck vehicle use on a small scale was a non-conforming use allowed in this jurisdiction, that was fine. The fundamental character, and character is the word they use, of the use had expanded over time and had substantially changed to a degree that it was no longer a protected non-conforming use. I want to relate that to our situation. Again, going back to the 60s, you had a transitional parking lot serving an adjacent commercial use with about 20 parking spaces on it. Throughout the last 50 years, that has continued. What we proposed to do and what we initially proposed to the zoning administrator was the use permit does not say anything about what that commercial use has to stay static over time. And that's another reason I point to the Knowlton case, because it does recognize that uses can change over time. It's only when they expand, intensify, change in scale that you have a problem. And so if you look at the language from Arlington's non-conforming use of land provisions, and I'm showing this not because I believe we're a non-conforming use, I'm just showing you the analogy to that case in Knowlton in terms of the Arlington zoning ordinance language lining up nicely with the language you'll see from Falls Church. From the jurisdiction in the Knowlton case, speaks in terms of non-conforming uses of land, continuing as long as they don't expand or extend onto another property, as long as they aren't discontinued or changed. Here, again, the character of the use of land that we're talking about is that R6 transitional parking lot, serving some required parking of the adjacent commercial use. Yes, we are proposing, if approved, to demolish the existing motel and replace it with a CVS pharmacy. However, as I mentioned a moment ago, the character of the use is not changing. That lot won't know that these cars are now parking to walk over to the CVS versus the Highlander Motel. The neighborhood won't know. The use of that land is not going to change. However, it is going to change only for the better. The intensity of that use, the degree to which the lot is used for required parking is, again, going down from 20 spaces that the motel needs to park on it today to the 7 going forward that the CVS would use. So that's the end of my presentation. I'm happy to answer any questions you might have.
questions for Mr. Pritchard? Mr. Owen.
I think I will have some questions, but I'd rather hear, if there's another side to this, I'd rather hear the other side first and ask questions. Could I recall the applicant at that time? Would that be?
Well, he'll always have the opportunity to come back, yes.
I have just one question.
Ms. Malice.
Is it your testimony that the owner of the motel is your client?
Yes, ma'am.
So your testimony is that your client has been operating in violation of the ordinance for the
No.
last 50 years?
No, the use permit,
No, because they have changed the configuration of the parking on the motel so that all 43 spaces don't fit there anymore.
well, so you're correct. If the building permit did show 45 spaces on the C2 lot back in 1963. We spent about 30 hours in the county files trying to find that building permit. I said Mr. Noxon kindly found that set of plans for us. He found them over at the Quincy Library in the Historic Archives. We spent about 10 hours over in the archives seeing what else was in there. And my testimony tonight is that the record is spotty at best over in the Virginia room in terms of Arlington zoning approval. So I don't know what happened subsequent to early 1963 when that building permit plan was approved. But it's absolutely the case that those 45 spaces were not provided all on the C2 lot. And I don't believe that that is a zoning violation because the use permit did not restrict the use of that transitional parking lot for customer use to only spaces above 45 on the C2 lot. It just didn't have any prohibition on required parking next door being parked on that R6 lot.
I guess that's a question of debate as opposed to fact.
Well, since you went ahead and asked that question,
Okay.
thank you. Can anyone tell me, was there a certificate of occupancy issued for the hotel?
There is a certificate of occupancy. My recollection is it doesn't specify parking spaces. It just talks about a motel.
Date of the certificate of occupancy?
I can look that up. I don't have that.
Just
right
if
off.
later on, if you could tell us the date of that certificate of occupancy, I think that would be helpful. Thank you.
Mr. Smith.
Chairman, well, I guess maybe Ms. Sanders might address this, but and kind of the other side of what Ms. Malice was asking, are you aware of any notice of violations on this property as a result of, say, the sign encroaching on those spots? Or
No, the subsequent to the building permit being approved, the sign permit was issued. That was going to take a spot that was shown on that building permit plan. And no, we have no record that there were any zoning violations of any kind. Certainly not related to shortcomings on parking. Thank you.
Other questions? We have one speaker. Todd Yates. Chamber of Commerce.
Madam Chair, thank you for your time, members of the board. I'm here tonight to talk to you about opportunity. And this is the opportunity to replace a 1963 motel with a state-of-the-art CVS. The motel in question, the Highlander, has been a 40-plus year member of the Arlington Chamber of Commerce. The parking lot in question has been the parking lot for that hotel since it was built in 1963. It was not added later. There will be no change in the function of that lot if this appeal is approved. As you've heard, there are 45 rooms at the hotel, and there's a drawing that shows 45 spaces. But today I walked the lot again just to make sure when I came before you tonight I could talk to you and with certainty. The drawing is not to scale. The drawing does not reflect the Highlander sign. And certainly the drawing, when you've seen the pictures, slide 16 of the slideshow you just saw, you see that there's only 2 spaces between the office and the sidewalk. It's impossible to put 3 spaces. The lot in question was asked for in order to make the hotel meet the criteria of 45 spaces. I think this is a great fit for Arlington. I began by saying this is an opportunity. It's an opportunity not only to replace this motel with a CVS, but it's an opportunity to provide a benefit to the community. The local community doesn't use the motel, the neighborhood. They will use a CVS. It's also an opportunity for the county. It will increase revenue to the county. It's also an opportunity to show the business-friendly attitude that the county is moving towards. It's an opportunity to move the county forward. It's an opportunity to show CVS that they're welcome in the community. Thank you.
Thank you. Questions for the speaker? Staff have comment? Any comments? Okay.
They don't make a presentation?
And the staff's recommendation is,
Do you have an argument or a presentation of any sort, either you or your attorney?
We would stand on our report. It's true that the hotel was approved in the 60s and that the lot adjacent to it that's zoned R6 was approved as a transitional parking lot. I think it's the position of the zoning administrator that that lot can still be used for public parking purposes. Whether or not it was actually ever approved for required parking for the hotel is obviously a matter of debate. We feel that it wasn't, but to the extent that one might suggest that it was, they don't get to use that R6 lot for required parking for all future business uses, by right uses. Essentially, what they're trying to tell you is that you should de facto rezone the property to allow us to use it for parking for all our by right business uses on the adjacent property. We don't feel that the zoning ordinance supports that. The zoning ordinance is very clear that required parking needs to be provided on site.
and the speaker has said CVS wants 25 spaces?
I believe that could be the case. We don't have any idea, at least I have no idea, what's necessarily driving that other than the size of the CVS that they choose to build. It's possible if that CVS were smaller, they could get their parking on that site.
Mr. Pritchard, could you address that? I assume that there is a footprint existing somewhere in the CVS world that would fit on the commercial site.
That was a question that was, I'm sorry. That was a question that was posed to us earlier, and we have been back to CVS a number of times. This has been going on for about a year and a half, and they've made very clear that this footprint, and there's some mezzanine space involved, is at the bottom of what they believe is even worth pursuing. And so we did go back and we did ask the question: could you get away with not having a mezzanine? Could you make it just a little bit smaller? And the flat answer has been, it's probably no longer worth the trouble anyway. But it's really not worth the trouble in a smaller store than the one that we've shared with the footprint we've shared with staff.
We're familiar with industries, particularly grocery stores, who aren't always flexible about what they want to build within the site. But I'm concerned that, personally, I'm concerned that we're having the industry decide what the size of the property is and what their parking wishes are, as opposed to perhaps what the ordinance would require, and trying to make it all work when it appears that the ordinance is clear that the required parking for the commercial use needs to be on the commercial site. That is my interpretation, at least.
May I respond?
Certainly.
So in preparing for tonight, I looked at the BZA how-to book that Mr. Noxon prepared, and I really enjoyed it. By the way, Drew, when I looked at the cover photo on that and the house that's prominent, I know exactly which house is the centerpiece of that, and I think it was a very artful choice, and I'll get off of that. The how-to book says, as you read the BZA's charge at the beginning, and so I don't need to tell you, is to look at the spirit and intent and purpose of the zoning ordinances. And I would submit to you, as I submitted to staff, is that to the extent that the zoning ordinance does not like required parking, and again, since 1983, I fully acknowledge the zoning ordinance doesn't let you put required parking on a transitional lot, R6. To the extent that's what we're trying to avoid, all I can say is industry is not dictating anything. Industry here is saying we could change the commercial use, still be a by right C2 use, to something I believe, as somebody who hopes to buy a home a few blocks south of here, would better serve the community and need fewer parking spaces on that R6 lot. So actually, to the extent you want to call use of this lot for 20 required motel parking spaces something we want to avoid in a nonconformity, industry's coming forward and the chamber's coming forward and saying, here's an opportunity to have 13 of those spaces be truly used for what's intended, which is excess extra parking, go down from 20 to 7. So that's our.
Thank you. Thank you. Any other comments or questions? Mr. Melnick.
I had a question of staff.
Go ahead.
Okay. My question to staff is, do you have a response to the case that he gave us a copy of, the Knowlton versus Browning Ferris Industries of Virginia, when it talks about the character of the nonconforming use, continued or changed? Do you have a response to, his argument that this is applicable? Because I noticed the Knowlton case wasn't mentioned in the report.
I mean, my response to that would be that the case is not applicable. In that instance, you had a property owner who had what was, I guess, considered a by right use, which morphed into something that was no longer a use that was permitted under the zoning ordinance, to the extent that, then it became an issue for Fairfax County, and they, cited him in violation. Here you have a business owner who has an ongoing concern and is choosing to change the use to another by right use, but is still trying to avail himself of the adjacent transitional parking lot for the required parking. I don't see them as similar at all. Again, I think there are options for the property owner here. Certainly the R6 lot could be rezoned if they want to use it for required parking. And so, it's our suggestion, we have to honor what's in the zoning ordinance, and not just the provisions that were cited in the acting zoning administrator's original determination in the staff report, but it's pretty clear in 14331 under parking and loading in the policy that it is the property owner's responsibility to provide all the required parking on site for all future uses except as otherwise permitted according to site plan or other examples set out in the zoning ordinance. And the zoning administrator couldn't look to any one of those exceptions and apply them here.
Okay, thank you.
Mr. Owen.
I'm a little bit confused about what the relief is that the applicant is seeking, because, part of that reason for that is that I'm not sure how to square what was in your brief and what you're saying tonight with what was in the original application. You've spent a considerable amount of time, I think, referring to the history of the site, which relates to the use permit that was granted on the R6 lot. But in the original application, there's barely more than a sentence of the whole application that's devoted to that premise. And the gravamen of the application is for a determination, an interpretation of 14.3.3.B.1, which has to do with off-site parking. And then the zoning administrator responded to you with a discussion of the transitional parking rules, which you haven't really addressed very much. So I'm a little bit confused about what ground we're fighting on here. Are you abandoning these other arguments?
The ground has shifted over the course of this case. Part of that is that we were dealing with the former zoning administrator for quite some time when we started on this path, and we were encouraged to pursue the route that was highlighted in the original application and part of the original determination request. And obviously nothing was promised, but we got the firm impression that that was the direction we were being guided to, and that was presumably something that the then zoning administrator believed was in line with the zoning ordinance. So we did focus on the off-site parking provisions in the original determination request. In the appeal, I spent a little more time than I did tonight, obviously touching on that point I also, in the brief, did cover the primary thing that I'm focused on tonight, which is the continued viability of the use permit and the use of the transitional lot. So I'm glad you asked the question. It is a little confusing how this thing has unfolded. If you ask my client back there if it's been confusing, or you ask the consultants that were originally working on this, or CVS, or maybe even me, it's been confusing for the last year and a half. I just want to respond to a couple of things Ms. Sanders said. First, the Knowlton case involved a non-conforming use that expanded in scale and changed in character, and the court ruled no longer subject to any protections as a legal non-conforming use. Just a little point of clarification there. It wasn't a by right use that was okay from a pure by right zoning ordinance compliance standard. It was one that was non-conforming but protected under the code, and so long as it continued to expand, it expanded, the court held, and came out. The other thing that was mentioned is, and we've discussed with staff, protecting the zoning ordinance and alternatives and going in for rezoning. Believe me, if we did not leave any stones unturned. We did not want to end up before the BZA, no offense to you guys. We looked very long and hard at whether there was a non-controversial rezoning potential site plan. That's it, for those of you who know me, that's normally the stuff I do and frankly prefer to do. But doing that at a cost that had any hope of keeping CVS alive and doing that was eliminated pretty quickly. So take that for what it's worth.
Did you happen to find out the date of the CVO?
I apologize, Mr. Owen. I have seen that date. I didn't bring it with me tonight. I don't know if staff has that date handy. I can tell you it was sometime in the 63, 64 time frame, as I recall.
Well, I guess the critical question in my mind is, was it before or after the use permit was granted?
After the use permit.
It was definitely after the use
Yes,
permit.
at I can answer that with certainty because the documents from the use permit approval and the staff report and the application do mention that construction was ongoing at the time of the application and the board hearing.
Well, I think thank you for your responses. I think all that is highly clarifying because for me, it was not really a close call whether or not it's got a long name, 14.3.3.b.1, could be allowed under these circumstances to allow what you're asking for. That's meant for a different purpose entirely than the situation presented here. And I don't think that it allows someone to transform an R lot into one that you can engage in commercial activity, namely the commercial parking on. And Mr. Knoxon's letter, I think, was correct in saying that if you want to engage in commercial parking on a residentially zoned lot, you have to refer to the transitional lot section. But if we're not arguing about that and we can just talk about the use permit, I think, to my mind, the fact that the C of O didn't even occur until after the permit was granted, and because the law didn't change until 1983, no one would have any reason to pay any attention to what the configuration was. From the day it actually started to operate, it was a free-for-all in terms of putting the required parking wherever you wanted, and then in 1983 the law changed, but the practice clearly was established. So I think, to my mind, I'm persuaded that there was probably never a time when all 45 spaces were actually used on this lot. And so I think that narrows the questions helpfully. So if I've now, does staff do you have any disagreement with?
Well, I mean, I would suggest to you that regardless of whether the lot was ever approved for parking for the hotel, it doesn't necessarily translate that transitional parking lot can be used for all future commercial uses on the hotel site.
That's really the main question from your perspective is they're okay as long as they have a hotel. And the question now, which is different than how it was originally, but the question is, since it is okay for them to have it as a hotel in their current configuration, would it still be okay for them to have a different use, to have the retail use?
And we can find no support for that under the ordinance.
Well, I think your support for that is partly the case that the applicant just presented, that Mr. Pritchard just presented.
I don't think you can expand the use permit to all for future commercial uses.
Opposite, which is that, in fact, a CVS parking lot is a very different experience than a hotel parking lot. A hotel parking lot, people come in, they park overnight, maybe they leave in the morning, but it's, per, parking space, it might be used at most once or twice a day. For a CVS, they might be used once or twice an hour, 24 hours a day. It's a much more intense parking use. And so, from the perspective of, is this basically the same as before? To my mind, it's completely different, especially as to parking. But that's just my opinion.
Other comments, questions? Motion?
I would like to say a few things about this.
Excuse me.
I'm the property owner.
Well, you're going to need to put in a parking, speaker's loop.
I'm sorry, I told him as the property owner applicant.
Well, you used your 20 minutes, so. Can you please speak briefly, please?
Thank you, ma'am. I would just like to say this hotel's been here for 53 years. That parking lot's been used for 53 years. I'm not going to speak in legal terms, but I'm going to speak in common sense terms. And I own other businesses in Arlington that are grandfathered in. If that parking lot was part of the commercial for 53 years, it's not going to change. The use hasn't changed, and it won't change under the term of the CVS lease. It's going to be a parking lot. Nothing is different. We're not building on the commercial, on the R6 piece. The CVS will be built on the commercial piece by right, nothing wrong. It's also 5,000, it's within 1,000 feet of a metro, which I don't know that was ever said. So there's parking exemptions. I think we're less than 6 parking spots short. She said it could be used. Common sense would tell me if it could be used for 53 years and there's no change in it, how can it be used today? You can use it, but you can't count it? That doesn't even make common sense. And she said you can use the parking lot. So common sense needs to prevail. It hasn't changed in 53 years. It was legal when it was built, and it hasn't changed use at all. How could the conclusion be at the end of the day that it's not legal today? There's nothing changed. And it was zoned right then. It should be zoned right now. And what Mr. Yates said, who's head of the Arlington Chamber of Commerce, he's also on Arlington's Economic Development Committee. I don't know if you all are familiar with that. They're saying it's a good thing for Arlington. It's going to provide more jobs. It's better for the neighborhood. This is a 53-year-old motel that's obsolete today. It costs more money to operate than it did. It's taxed at over $40,000 a year. It makes sense for everybody, and it's by right.
Thank you.
Thank you.
Comments or questions?
I'm prepared to make a motion.
Ms. Malice.
I would move that the Board of Zoning Appeals uphold the decision of the zoning administrator to deny the use of the 823 North Kenmore Street for required parking for any redevelopment of the 3330 Wilson Boulevard, per the resolution attached in our staff report.
Is there a second?
Second.
It's been moved by Ms. Malice and seconded by Mr. Owen. Discussion? All those in favor?
Sorry, just briefly.
Mr. Owen.
Our responsibility is to interpret the zoning ordinance, and we are not permitted in most cases for an appeal like this to consider the merits of the underlying project. So I just want to clarify that that's not the basis of my decision. I'm not saying that the proposed commercial use of the project is a bad one, or that it isn't even in the interest of Arlington County, but the county board has written the zoning ordinance the way it has, and considering that the county board has written it that way, I feel the zoning administrator correctly interpreted it. That leaves a number of other options open to an applicant. They could ask the county board to change the ordinance. To change the ordinance. There are, as the staff pointed out, there are other ways to economically develop the property. This is not the only one, even with a CVS, to rezone the R6. So the county board provides other avenues. But our responsibility under the law is just to interpret the ordinance, and I think the interpretation of the ordinance, for me, is clear on this one.
Thank you.
Chairman,
Mr. Smith.
By way of discussion, I don't disagree with Mr. Owen at all. But I guess my point is that this really, to me, presents a design problem for CVS. The transitional parking can't be continued in that use. I don't agree 100% with Mr. Owen with respect to hotel CVS parking uses being very dissimilar. They're slightly dissimilar, but I think the issue really is its characterization. It's transitional parking. And CVS has just got a design issue. If they want that location, they just have to better design their store to accommodate the limitations on the plat.
You ready for the vote? All those in favor of the motion?
Aye.
Opposed? Motion carries. Thank you. Next case.
The next case is V-11120-16-APP-1, and this is an appeal by Robert Jones of a violation notice stating that the building on the subject property is an unpermitted multifamily dwelling. This is in the C2 zoning district, premises known as 5029 23rd Street South, and the motion is to defer this case to the August 10th BZA hearing.
Madam Chairman,
Mr. Owen.
I move that on case V-11120-16-APP1, that we defer the item to the August 10th BZA hearing.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Aye. Thank you. Next case.
Next case is also a deferral. This is V-10888-14-UP-5. This is a use permit request by Elaine Capusta to permit a setback of 10 feet to the eve of a new third-floor addition from the 21st Road right-of-way instead of 25 feet as required, and also to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way. This is for the construction of a new third-story addition above the existing second-story walls. It's in the R5 zoning district on a premises known as 4133 21st Road North.
It's recommended for deferral, right?
Correct.
Go ahead, Paul.
Madam Chair, I'd like to make a motion.
Mr. Malkin.
In case V-10888-14-UP5, I move that the BZA defer the use permit to the August 10th, 2016 BZA hearing.
Second.
Moved by Mr. Melnick, seconded by Ms. Malice. All those in favor? Aye. Thank you. Next case.
The next case is V-11134-16-UP-1. This is a use permit request by Peter and Monica Irvine. This is to permit a setback of 3.7 feet to the second-story eave, 3.7 feet to the eave, and 4.9 feet to the wall of the new two-story addition from the right side property line instead of 8 feet as required. Also, 8.7 feet to the second-story cantilevered addition from the left side property line instead of 10 feet as required. Finally, an aggregate side yard of 12.4 feet instead of 18 feet as required. For the construction of a new two-story rear addition, a second-story rear cantilevered addition, and an eave overhang for a new second-story addition above the existing first-floor walls. It's in the R6 zoning district, premises known as 4901 16th Road North.
Thank you. Questions for staff? Hear from the applicant, please.
Good evening. I'm Monica Irvine. I'm here with my husband, Peter Irvine. We'd like to thank the board for their time tonight and also Mr. Noxon for his time as we've worked our way through this application process. For our renovation, we really wanted to preserve as much of our 1939 home as possible, knowing that its placement on the lot was going to be challenging because it was sited and constructed more than a decade before the zoning ordinance was enacted. We've worked really hard to keep our renovation plans in line with the neighborhood, beginning with selecting an architect that's designed 2 other renovations on our block. In our revised plans, we have made the majority of our addition by right, both over our existing structure and in the back of our home within the required setbacks. There are still 3 modest areas for which we are asking a use permit. Most importantly, on the first floor, we are hoping to expand our dining room on the right side of our property to accommodate additional seating for our family and friends and align it with our new kitchen design. Because the original dining room was constructed 4.9 feet from the property line, we are asking approval to extend that existing wall another 7.1 feet only to allow us to fit a scaled dining room, and this would be a 1-story extension on that side. The design's intended to minimize the impact on our neighbor, and we believe that it will do that successfully, particularly because there is a 6-foot privacy fence on that side. The overhang that our architect has designed is for 12-inch eaves all around the structure, which would be into the setback given the current placement of our existing structure on the lot, in addition to the new small dining room addition. Finally, we have a left side property. There's a small portion of a cantilevered second floor addition that it would be in line with the existing structure, but again, would be into the current setback requirements. We understand the staff is recommending approval of our use permit, which we appreciate, but with a setback of 4 feet to the eave instead of the 3.7 feet, and 5 feet to the wall instead of the 4.9 feet for our new addition on the right side property line. Since we are keeping the existing wall intact for a dining room, this small change would require a 1 to 2 inch jog in the middle of the dining room, which would be visible interior and exterior to the home. We feel like that would be a negative impact on our design, yet not, but moving it and including that jog is not going to really add anything to our neighbor. And in fact, our neighbor on the right side has submitted their support for these revised designs. And we're happy to elaborate further on that. So we would respectfully ask the board to approve our the alternative resolution and grant us a special use permit consistent with the submitted drawings in the plat. We've worked really hard with the staff and our neighbors to achieve a design that we believe is consistent with the neighborhood and the requirements of the special use permit.
Thank you. Questions for the applicant? Thank you.
Staff report, this is a quibble. The staff report said there were 7 letters from neighbors, and I only saw, I'm sorry, it said 9 letters, and I only saw 7. Don't know if a couple were omitted, but I noticed that the next door neighbor, not in, next door neighbor at 95, not divided.
8.
Did I miscount?
I think you counted correctly. I think either I counted correctly or 2 of them were left off. It's possible.
I have a question for the applicant.
Okay.
Would you mind coming back up?
Ms. Irvine?
We have letters from your neighbors in our packets, but if I looked at this correctly, we don't have a letter from your neighbor at 4905. Is that correct?
That is the...
That would be your left-facing neighbor.
Our left-facing neighbor. We have been in touch with our left-facing neighbors. They are actually posted abroad, and there are renters in the home right now.
Okay, all right. Thank you.
Any other questions?
Yes, the staff report is recommending denial of setbacks, denying the setbacks 3.7 feet to the eaves and 4.9 feet to the wall of the new 2-story addition from the right side property line. And I'm just wondering, from your perspective, what would be the impact of following the staff recommendation? What would be the detriment from what you're trying to achieve?
So our existing wall on that on that side is at 4.9 feet. So if you look at the proposed drawings for the first floor, you'll see that what we're doing is extending that wall another 7 feet to make the dining room one larger room. So by asking us to move in by whatever the 1/10 of a foot is, that's going to cause us to have to jog in the middle of that dining room to achieve an extra 1 to 2 inches in order to meet the staff recommendation, as opposed to keeping it in line with the existing wall.
Thank you.
Mr. Melnick?
Yeah, I'd like to make an observation. So I noticed in the staff report, out of the 3 properties mentioned, one of them actually does have a side yard setback of 3.6 feet, which is actually closer than the 3.7. So that's a third, of the 3 properties that were found. And I fully appreciate, eaves and the look of a house, because I was looking at the design of this, and clearly the eaves, it'd look odd if eaves were cut off, or so the eaves really make the design. So those are my 2 thoughts.
Madam Chair?
Mrs. Malice.
I wouldn't have mentioned it, but you mentioned the privacy fence as a justification for your request. Does the fence belong to you?
No, it's our neighbors.
So,
It was constructed when they constructed their new home.
okay, so it would be up to your neighbor whether they continued to have a privacy fence there.
Yeah, they put it in just a few years ago when they constructed their new home, and the intention, as far as we know, is that it would continue to be there.
But it would be their choice.
Any other questions, comments? Motion?
Madam Chair?
Ms. Malice.
I can find it. I move that the Board of Zoning Appeals adopt the attached resolution.
The alternative.
Yeah, adopt the attached alternative resolution approving the use permit V11134-16-UP-1, subject to the conditions listed in the resolutions, in the alternative resolution.
Approved. Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Aye. Next case.
Excuse me. The next case is V-11058-15-UP-2. This is a use permit amendment request by John and Dorte Hardage to permit a setback of 20 feet to the new garage from a 24th Road North right-of-way instead of 25 feet as required, and 3.6 feet between eaves and 4.5 feet between the wall of a new garage and the wall of the existing home, then 0.5 feet between the new garage and a new stairway instead of 8 feet is required, and this is for the construction of a new detached garage and a stairway in the rear yard. This is in the R6 zoning district on a premises known as 4647 24th Street North.
Thank you. Questions for staff? Mr. Melnick.
I don't know if we touched on this before, but is there any input from the fire marshal about what is the minimum for fire safety and that sort of thing, the minimum that needs to be between buildings? I was just curious as to what that is. Have you all had feedback?
I actually recently spoke to one of our fire protection specialists in the inspections department, and they stated that if you are 5 feet or less between 2 buildings, you just need a higher fire rating in the wall construction. So they would have to have a little more insulation and that sort of thing, a higher fire rating between the 2.
Okay, thank you.
Thank you. You hear from the applicant, please?
Yes, ma'am. Thank you for having me tonight. I'm John Hardage. My wife, Dorta, is sitting in the back here. This is my 3rd visit over the past 13 months before the board regarding our project. We worked with the staff over that time to refine the project and address our mutual concerns. Related to that, I want to thank the BZA staff and our contractor team, the NVS team, who's also with me here tonight. Our proposal would amend the existing use permit granted on October the 14th, 2015. Your approval of the amendment would allow us to place the proposed structure in a more practical and aesthetically desirable location.
Yep.
The amendment also provides for the structure as a garage, not a carport as originally proposed, which will enhance compatibility with neighboring structures. The neighbors most affected by the project, the owners of 4651 24th Street, my immediate neighbor to the left, with whom we share a property line, provided an enthusiastic letter of support, which I think is part of your package. Provided at the October hearing last year were no objection letters from residents of 4651 and 4655 24th Street North. Residents of 4719 and 4625 24th Road North verbally indicated to me, personally, no objection, but never put anything in writing. Our neighbors 2 doors up at 4655 24th Street North have a through lot just like ours with an existing garage structure almost exactly like what we're proposing here. So I would highlight and echo the staff conclusion that the proposal would promote compatibility of development with the surrounding neighborhood, and just finally note that the proposal, if approved, would allow us to return the existing driveway in the front to a green space and foliage, which is what we intend to enlarge the front yard. I'm happy to answer any questions. I don't mean to take up the board's time. I think you've been over this several times already, but I'm happy to respond if you have any questions.
Any questions for the applicant? Recall the case well.
Yes, we just received right before the hearing 2 letters from neighbors in opposition. I just want to see, have you seen those letters? So there's a letter that we got from William B. Monroe at 4719 24th Road North, and one from Alan H. Williams, 4729 Old Dominion Drive.
Old Dominion Drive?
Yes, 4729 Old Dominion Drive, which is right at the, in between 24th Street and 24th Road, facing Old Dominion Drive.
Okay.
So he's on the corner of 24th Road and Old Dominion. So you've not seen these letters? Okay. Do we have any extra copies of them that the applicant might be able to review?
If you're willing to give one away, I know you all just passed them to me at the end. I have more electronic copies. I can always print more. So
if in a moment, if you have a chance to read, depending on how long our hearing goes on this item, if you have a chance to read them over, I might ask you what your response is to those letters.
Happy to.
Thank you.
Okay, just a moment. Do we have speakers? No speakers. Okay. Would you like to pause momentarily while he reads the letters?
Or if you want to tell me what their points are, I'll respond to those too, whichever you prefer.
We just got them ourselves. So I think they appear to address parking, predominantly parking needs on 24th Street and 24th Road. But I'd like to let you read them and see if you can respond.
5 minutes or 2 minutes?
I'll leave it up to the chair.
Or I can stand here and read it, whatever you prefer.
Just read through them quickly so that you can comment on those, please.
Okay.
You remember this?
if I can respond to a few of those concerns, well, the main concern about the parking, the issue has been in the past when the previous case, the original 11058 came through, one of the main concerns was removing parking on 24th Road North. And the issue was that a driveway can be built there with a curb cut by right. So whether a garage or a carport is put in, a driveway could just be put in with no need to come to you all for approval. So that's not really an issue that staff felt was, anything that would change the merits of the case.
Or it could be just a driveway to park, a parking pad.
Yeah. Exactly.
Yeah. Okay.
While he's reading it, Mr. Noxon, I'm reading that we're going to remove a driveway from the front yard.
Correct.
And we're going to have driveway in the backyard now.
That's correct.
And here in the letter, one of the arguments is that they don't see on the plans where that's going to happen.
Well, even if that parking area...
There's no coverage.
Exactly, no coverage issue. So even if the parking remained in the front, they're meeting their coverage either way.
Okay. Can we have your response, please?
To a specific question or to the letter in general?
If you have any comments before, because...
I would just say it's a non-issue, frankly, for the reasons that Mr. Noxon just pointed out. If I wanted to, and I have consulted an attorney to clarify this point, I could just create the driveway in the back instead of in the front, which is what I would do if I couldn't build the structure, but I would like to build the structure. So I don't think it's an issue, and I don't really understand why he has, standing is not the right word, because he's remotely close by, but he's a good distance. He's certainly not one of my immediate neighbors. He's at the top of a hill on 24th Road and Old Dominion.
Okay, thank you.
Don't think it's relevant.
Okay,
frankly.
thanks. Any other comments or questions? Do you have a motion?
Madam Chairman.
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting V-11058-15-UP2, subject to the conditions which are listed in the staff report.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye.
Thank you.
Thank you. Next case.
Okay, the next case is also going to be a deferral. This is V-11151-16-VA-1. This is a variance request by Thomas and Vicky Moffitt to permit a total lot coverage of 60.1% instead of 45% as permitted. It's for the construction of a new rear deck. It's in the R6 zoning district on a premises known as 6030 22nd Street North. And it's being deferred because the applicant is working with the contractor to try and figure out where to remove some of the existing coverage on the driveway and see if he can work that angle and hopefully get approval if he comes back.
Is it deferred to a date?
The August 10th date.
Okay.
Madam Chair, I move that we, the BZA defer V-11151-16-VA-1 to the August 10th hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor? Aye. Thank you. Next case.
This is V-11154-16-UP-1. This is a use permit request by Terry and Elaine Eby, and this is to permit a setback of 2.9 feet to the eave and 3.4 feet to the wall, a new one-story addition, a landing and a stairway from the right side property line instead of 8 feet is required, and an aggregate side yard of 14.8 feet instead of 18 feet is required. This is for the construction of a new one-story right side addition with a landing and a stairway. It's in the R6 zoning district on a premises known as 3817 13th Street South.
Thank you. Questions for the staff? We'll hear from the applicant, please.
I have some handouts, supplemental.
You all noticed there were some additional letters of support that were sent in to me today. I think there were 2 of them in your packet.
Thank you.
You ready? Okay. Dear Madam Chairwoman and members of the board, good evening. My name is Elaine Eby, and I want to thank you for the opportunity to speak to you tonight regarding our application for a use permit. My husband Terry and I have lived in Douglas Park for over 33 years, 26 in our current home. We love this neighborhood and fully anticipate living here for the rest of our lives. Last October, my husband and I decided to apply for a use permit. Since then, I have thought a lot about what I would say at this meeting, if in fact I needed to convince you to approve this permit and this project. Most importantly, however, I wanted to convey to you the feelings I have for my home, the place where we have raised our 2 children and share so many fond memories. I had hoped that I would have to stand up here and say thank you, and that would be it. You would approve the use permit. However, that is not the case. County staff have recommended that our petition be denied, and I must now stand here in front of you and convince you in less than 5 minutes why you should approve our use permit. If I understand the staff analysis correctly, our application meets 3 of the 4 criteria listed by the county for approval. It is not, however, compatible with the surrounding neighborhood because placement would not be similar to any structure on the properties surrounding the property. I'd like to make several points now. The first point is zoning and undue hardship. Our 13th Street neighborhood is zoned R6, which requires the lots to be a minimum of 60 feet wide. My lot, as well as many others on 13th Street, are only 50 feet wide, and therefore we all live on non-conforming lots. This creates an undue hardship for me as well as my neighbors and unreasonably restricts the further development and improvement of my property. If my lot were conforming, meaning it was 60 feet wide, there would be no issue, and I would not be before you tonight. Point 2, similar encroachments. The first example is Ann and Horacio's house next door at 3813 South 13th Street. Until November of 2015, this house was totally enclosed for at least 35 years, with approximately 18 feet of it situated within 35 inches of the property line. When Ann and Horacio bought the house, they renovated a portion of it, an 8 by 17-foot section, creating a screened-in porch. Though no longer enclosed, this is an example of a similar encroachment, in my opinion. A second structure is located across the street from us at 3804, the house of Rebecca and Jamie Kraft. This house extends to within 50 inches of the fence or property line. If you look at the zoning map for 13th Street, you can see how many homes on our street look like they are very close to the property line. All these homes encroach on the property line and cause an undue hardship to anyone wishing to expand horizontally their home. The homes located at 13th Street and South Kenmore is another example. These are huge, 3-story homes with very small setbacks, between 8 and 10 feet separating the two homes. These homes were identified as compatible with the neighborhood, and I would submit are similar and consistent with the change we would like to make. Point 3, privacy. We love our house, but we also love our privacy. Since Ann and Horacio's side porch renovation, we feel like we live in a fishbowl. We really like Ann and Horacio and their 2 young children, but we didn't sign up for commune living. We must keep our shades drawn on that side of the house for privacy, and we feel uncomfortable walking around in even our pajamas. My husband has also painted the window panes on our side door to block the view. We really like our neighbors, but sometimes you need privacy, and I believe that privacy is a building block of neighborliness. Our proposed project would solve these privacy issues for both Ann and Horacio and ourselves. Ann and Horacio are 100% supportive of our project. Point 4, economic hardship. I recently had a conversation with Claudia Webb, co-owner of Mike Webb Realty. She wrote me a letter dated June 13, 2016 that read in part, I'm a licensed realtor and I believe that the addition would increase the value of the property and the surrounding properties. I also do believe that if no addition is added, the value of the property would decrease due to the lack of privacy. The addition benefits the homeowner as well as the neighbors. Point 5, fewer steps. This addition would help both my mom and my aunt when they visit. It would also help my husband and myself in 10 or more years when we're no longer to make it up the front porch. I recently read in Arlington Now that Arlington is ranked the 2nd best place to retire in the United States. I hope that you will consider the addition as another way that Arlington embraces its retirees. Point 6, neighborhood support. I originally submitted signatures from 14, may I continue? It's only submitting the project. I also have the support of the Douglas Park Civic Association. I would now like to submit to you the signatures of an additional 28 neighbors, as well as emails from Joy and Sharon, who cannot be here tonight. No one I spoke to in the neighborhood was opposed to our project. Thank you for your time.
Thank you very much. Any questions of the speaker? Applicant? We have 6 speakers. So I'll go ahead.
Chairman, may I ask a quick question of the staff?
Certainly.
Okay, my question is, so she brought up a number of properties here where she's saying that, the encroachment, is, that they're pretty close to the lot line. And did you have a chance to, check the property she's mentioning? Because in your report, it looks like you're saying staff has not identified any similar encroachments in the vicinity. And I just wanted to make sure, that what she's bringing up, that, what the staff's position is on those.
What I do when I write these reports is I research a pretty large surrounding area, and I pull all the plats that I can find on those properties that we have. It's possible that there's a plat or 2 that are missing, but for the most part, we find most of them. And that's how we make that determination. We look at the distance between the structures and the lot lines. And we're usually able to pull a lot of those in this neighborhood. either I didn't find enough or I didn't find enough that showed that they were closer than, 4 feet, 3 feet, that sort of area.
Okay.
Thank you. Okay. I'm going to call speakers 2 at a time. Debbie Hill, to be followed by Denise Boyd.
Hi, my name is Debbie Hill. I've lived in the Douglas Park neighborhood since 1993. I'm speaking to you regarding the proposed changes to the house of Terry and Elaine Eby at 3817 13th Street South. I live at 1616 South Pollard Street and am in support of the changes, including the use permit that the Ebys have proposed. The changes will not only enhance the Ebys' home, but the neighborhood as well. I have no objections to the project and am hopeful that you will grant their use permit and allow them to proceed with improvements as planned. Thank you.
Excuse me, what was your address?
1616 South Pollard.
Thank you.
Okay. Denise Boyd, to be followed by Mary Vogt.
Hi, I'm Denise Boyd. I'm a homeowner on 13th Street as well, 3912, and have lived there for 22 years. Me and my husband both totally support the Ebys in what they need to do to their house to make it comfortable. I really can't believe the county will not give them a permit to do that when the county approved this obnoxious, obstructive, obtrusive structure. And this is our house next to this, and this is what we have to live with. This does not fit the community, and more particular, our street. And the Ebys just want to enclose their little porch and add a door and some steps. I mean, I really can't believe you wouldn't give them the permit to do that, which is a shame, because just look at this. I mean, the county approved this. This does not fit our community or our street at all. And it's obnoxious. But yet, the county won't give them a permit to make such a small change.
Excuse me, ma'am. What's the address of the house that you're referring to? Do you know?
This one?
The street number?
I live at 3912. This actually, I believe, is a Quincy Street because this is the corner of Quincy and 13th, which is right across from Randolph Elementary. I mean, look at this. It's obnoxious.
Thank you.
Okay, if you want to bring those up, we can look at them. Thank you very much. Mary, to be followed by Ann Correa. Oh, okay. Thank you.
Hi, my name is Mary Boat, and I'm a homeowner on 13th Street. I live at 3917 13th Street. I look at that monstrosity of a house. It's across from me and to the right. I am completely 100% supportive of this small addition project. I believe it is tasteful and that it'll fit right in with the character of our neighborhood. Elaine and Terry have a beautiful home, and they have done a wonderful job of staying true to and preserving the historic charm of the Cape Cod style home, which is the model home style of our neighborhood. They only want to make a minor improvement that will better serve the needs of their family. In no way will this be one of those massive mansion-type additions. It looks to be exactly like many other homes already in our neighborhood. I respectfully urge you to consider approving this project. I strongly believe we want to encourage people to put down roots in our community, invest in our local businesses and schools. But in order to do that, their home needs to fit their needs. And obviously within a respectable boundary, and I believe that their addition is within that boundary. So I think it's a modest project, and I urge you to support it. Thank you.
Thank you. Ann Correa, to be followed by Gertrude Creed.
Hi, I am Ann Correa. I live at 3813 13th Street South. My house is the blue one on the right that you see in the picture here. My husband and I moved into the house in December. We started renovating the house in October. And when we bought the house, the part of the house that you see there was enclosed. And we decided to change it to a screened-in porch. And so it wasn't until it became a screened-in porch that we realized how close we were indeed to our neighbor, because we are very close to the property line. And like Elaine said, we get to we experience a lot of neighborly conversations that probably a lot of people would not otherwise. My family spends all of our time on the porch, and Elaine and her family come out often. They use it as a thorough way, and that's lovely. But it would be an improvement for both of us if that was enclosed. And just additionally, Elaine has one of the prettiest houses on the block. She's done numerous renovations, and all of them are in keeping with, keeping a charming neighborhood. And so I would trust her to make this change before anybody else. And so I would definitely encourage, my husband and I are fully supportive of the improvement.
Thank you very much. Gertrude Creed, to be followed by Rebecca Kraft.
Good evening. My name is Gertrude Creed, and I have lived at 3800 South 13th Street for 46 years. I'm here to ask that the Zoning Board grant the use permit requested by Terry and Elaine Eby for their property at 3817 South 13th Street. My understanding is that the only reason for denying their use permit is, and I quote, "The proposal would not promote compatibility of development with the surrounding neighborhood because placement is not similar to the structure on properties surrounding the subject property," end of quote. This is not true in my mind. Permits have been issued for building huge, unattractive houses on several streets surrounding 13th, including most recently an overpowering structure at the corner of South 13th and South Quincy, and another house at 3726 13th Street South. The house on Quincy Street, I believe, is 1301. You were asking the address. Neither of those houses have any similarity to any dwelling on South 13th Street. I also point out that this proposal just reverses what existed prior to the enclosed porch next door at 3813, that was just mentioned, was rebuilt as a screened porch, and closing Eby's porch would result in a placement very similar to what existed less than 1 year ago. Now the open porch is on this side, the closed structure is on this side. They were reversed prior to this. The enclosing and slight extension of the existing structure will provide desirable privacy for residents of both houses, 3813 and 3817 South 13th Street. An entrance with easier access by handicapped or elderly relatives now and for themselves in future years is proper planning. The Ebys want to stay in the neighborhood for many more years, and their neighbors welcome that plan. Is not planning ahead what Arlington is all about? No residents of our neighborhood have expressed concern about this proposal. Even our civic association is for it. I say grant use permit to the owners of this property. I'm confident it will neither detract from our neighborhood nor Arlington County in any way. Thank you.
Thank you. Rebecca Kraft.
Madam Chair, board members. I'm Rebecca Kraft. My husband and I have lived on South 13th Street since 1993. The Ebys live across the street from us, and they were here when we bought our house. I'm here to speak in support of their use permit request. Terry and Elaine are really good neighbors. The improvements they have made to their house have improved our street. They are designed with excellent taste and style, and they've been risk takers and leaders in investing in our street. When they added their major addition in the 1990s, theirs was the first on our street in decades to have a major addition. During this period, property values in Douglas Park were very soft. Housing prices stagnated or they declined. People struggled with the choice of staying in our very small houses or moving or turning their houses to rentals. Large additions were unknown. The economics were against it. The Ebys were the first to invest a really large amount in their home. Their two-story rear addition was a very impressive expansion that actually shows very little from the street, and they later added a very gracious front porch. We really appreciate their commitment to our street, and Elaine has opened their lovely home on many occasions for ladies' night, progressive dinners, a farewell dinner for dearly beloved octogenarian neighbors, pampered chef parties, the list goes on. I'm concerned that the recommendation before the BZA is to reject the proposal as being incompatible with the surrounding neighborhood. As I see it, in 2016, the prime threat to our neighborhood character is tear-downs and oversized infill structures. Some of these blend into the neighborhood, but others don't. I understand the purpose of the EB's addition is to provide privacy between their home and the neighbor who is in favor. Narrow side yards are not unknown on our street. One of the side yards on my house is 4 foot 2 inches from our closed porch to our neighbor's retaining wall. It is possible that the previous owner of our house closed the porch for privacy's sake. I have some more to say, but it won't fit in the timeline. It's in the letter that I sent, and you've got the message, I think, pretty loud and clear.
Thank you very much.
Thank you.
Any other comments or questions?
Just a quick question.
Mr. Owen.
For staff. If I read this correctly, the porch itself was obtained through a variance.
That's correct.
But this is being requested through a use permit, and I'm wondering why might this be happening through two different routes on these two different occasions?
Because the ordinance changed after 2006 to allow use permits for placement as opposed to variances. This is after the Cochran ruling. So it's a different process now to remove something and place it in a setback than there was back then. Back then, everything was just a variance for placement, coverage, height, anything was a variance back then.
Thank you.
Madam Chair,
Mr. Melnick,
I'd like to make a motion.
please.
Okay, so in case V1115416UP1, I'd like to move that the Arlington BZA grant the use permit with conditions as advertised. In other words, go along with what the applicant is requesting, with conditions.
Alternative?
Yeah, the alternative resolution, with the conditions as stated.
Is there a second?
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor?
Aye.
Aye.
Next case.
The next case is V-11159-16-UP-1. This is a use permit request by Kendrick and Heidi Robbins, and this is to permit a setback of 17.9 feet to the eave, 18.4 feet to the porch base from the North Edison Street right-of-way instead of 21 feet as required. It's for the construction of a new front porch. It's in the R10 zoning district on the premises known as 3427 North Edison Street.
Thank you. Questions for staff? We'll hear from the applicant, please.
Good evening. Thank you for your time and consideration this evening. I'm Heidi Robbins, one of the owners. My husband is conveniently on a business trip, and he actually did most of this paperwork, so now, it's my turn. We've owned this home a little over a year. This is our 13th home in 21 years. Yes, my husband is military, and he just retired, so we are now going to call Arlington home permanently because we absolutely love living here. This was our second duty station, or second time being stationed here, and love Arlington, so we're here to stay. So we purchased this house in February of last year. The picture's a little dark, but as you can see, that whole front area is a deck, a wooden deck. And it's kind of got a contemporary flair to the front facade. I'm more of a traditionalist. And so what we would like to do is we'd like to rip off that wooden deck, which would provide more grassy area for us. But that's also the west-facing side of the house. So in the afternoon, particularly in the summertime, we have to close every single window and pull all the curtains and blinds to try to keep the house cool, because there are quite a few windows. You can't see where the maple tree is, but we have 3 more windows right there, and so the direct sun. So we're hoping the porch will actually add a little bit more shade for us, but also an overhang, so we can have protection while people are standing at the door and they're not getting rained on, because right now there's just sort of a pergola structure. There's nothing to protect you from the elements. And so if you look at that wooden structure, it's actually much further out than the new front porch will actually be. And I'm not sure what went into designing and planning this deck, but this was how we purchased it. So, yes, we would like to rip off the deck and put on a new front porch, and it's going to be 6 feet wide by 26 feet, so it'll go only about halfway across the front of the house.
Okay, thank you. Any questions for the applicant? Ms. Malice?
Were you aware that we often look for support from your neighbors?
Yes, and all of our neighbors came to our house and said, hey, what are you guys doing? This is great. So they did not write letters or what have you, and we probably should have asked them to sign something, but verbally, we've been accosted several times by our neighbors wanting to know what we're doing and how cool it is. So our neighbors are directly across the street and to the two on the sides have given their full verbal support. So, and there's a house, as you noticed, or as you noted, your staff did in the report, there's actually a house 3 doors down at 3433 North Edison that did the same thing a couple of years ago. So, of course, they were the ones that told us how to do it.
Madam Chair.
Mr. Smith?
Is Ms. Schwartz one of your neighbors? Is she nodding in support? No. No, okay, friend, okay. I'm a lover of porches. I think they're like an additional room. This is one of the oddest front yards I've seen in a number of years on this. If any house demands a porch, this one does.
Thank you.
Mr. Smith?
If it's the board's pleasure, I'd move that the Board of Zoning Appeals adopt the attached resolution V- in the case of V-11159-16-UP1 to approve the request as submitted.
Second.
It's been moved by Mr. Smith, seconded by Mr. Owen. All those in favor? Aye.
Thank you. Appreciate it.
Next case?
This is V-11160-16-UP-1. This is a use permit request by James and Catherine Luzius to permit a setback of 4.9 feet to the eave and 6 feet to the wall from the right side property line instead of 8 feet as required. It's for the construction of a new right side porch. It's in the R6 zoning district on a premises known as 2315 North Powhatan Street.
Questions for staff? We hear from the applicant, please.
I'm Kay Lucius, and I'm the one who's done most of the paperwork. My husband is at home with our daughter, and I am requesting the granting of the use permit. We would like to just take off right now we have an existing wooden deck that is in serious disrepair from insect damage, just general age. We bought the house in 1999, and it was kind of falling apart at that point. So we would like to replace the deck with a screen porch and a patio combination, and so that's what we're here for.
Okay.
I'm trying to think. That's about it.
Any questions for the applicant?
I noticed that we don't have any comments from your neighbors. Were you aware that?
There's a handout.
There's a handout.
Well, I know one of my neighbors I've been in touch with all of my neighbors about it. One of my neighbors said he was going to submit a letter, so I didn't see any notice of that.
We have a letter and a speaker slip from him.
Okay.
The letter we have is from the resident of 2321 Powhatan Street, which is the one behind you, I think.
Right.
And the one we might be that I'm particularly interested in would be the neighbor right
side.
On the right side, legally to your rear physically, 2313. Have you talked with them?
I have talked with them numerous times about what our plans were and stuff. As they've never expressed any negativity towards it. But I have no idea what he'll actually say here. He has not said anything negative about it towards me. So.
I'm sorry, Mr. Owen, which you were talking about?
So the configuration of this house is that the front, what an ordinary person would describe as the front door, faces north.
Right. So our front door is on essentially the pipe stem driveway. So the back of our house is on the right side of the lot. And because of the way there are stairs down into the basement, we cannot build into like the back of the lot because of where the stairs are. So, and our house is sort of catty corner on the lot. It doesn't run parallel to the lot line. So it's really just sort of the one corner of the porch that's, a bit out of the thing because of the eaves and everything. And we didn't realize that there was a different setback until we got into this whole process. Because we have a deck, we're essentially using the same space that the deck takes up, but we're turning it into a screen porch.
So the issue from the standpoint of understanding the neighbors' views is that because of the location of this deck, which is on the photo with the red target on it right now, the deck is where the trees are to the right. Is that right?
Yes. So right now there's that deck.
So the neighbors that could see the deck would be the house to the right.
Yes.
As well as the two houses above yours.
Yes.
And actually anyone who walks by on the street as well. And the two houses below, across the street from you, across Powhatan Street from you. So I would ordinarily be keenly interested in all of those neighbors acknowledging that they've been aware of the plans, that they have no objection to the plans, and particularly the neighbor that would be the closest to the deck. That would be customary for the BZA to have some information from those neighbors.
Right.
So that I think that was my question.
Okay. Well, yeah. So I have been talking to them. They know what we are planning on doing, and as I said, I've not had anything negative. I have a text from one of my neighbors who's across the street who said it sounds good. So, that.
Mr. Knoxon, could I, sorry, but were these neighbors notified by the county of tonight's hearing?
Yes, they would have been. They would have been sent a letter, and they probably would have seen the big yellow placards on the poles around the block there.
It leaves us in a little bit of a quandary as to...
Well, we have a speaker, so maybe we could proceed for the moment.
All I can say is the neighbors that have actually talked to me have been supportive of it.
And there's no doubt that may be the case. It's just customary for us to have some evidence to that effect. So if you would take a seat for a moment, I have a speaker, Leonid. Is that you? Leonid Kopelev? Okay, wait a second. I got two people here. Oh.
I'm Leonid Kopelev.
You're Leonid? Okay, thank you, Leonid. Go ahead.
Hello, good evening. I'm owner and resident of 2321 North Powhatan, which is a pipe stem. They are not on a pipe stem. We are on the pipe stem. And I come here to support the application of my neighbors. As has been mentioned before, the place where one could see the current deck is not just our houses, but the street. So as the owner mentioned, this is an old deck, and our family thinks that by replacing the deck with the porch and the structure, which now isn't really attractive, with the structure that would be attractive would be improvement to the neighborhood, in particular to our house, because you know, we are on a pipe stem, and many people, instead of our house, they come in front of 2315. So we think the structure would be an improvement not just for them, but also for us and for the neighborhood. Thank you.
Thank you very much. Any questions? No, thank you. Sir, is it your intention that you wanted to speak?
Yeah, may I proceed?
I don't have a speaker slip for you. I don't have a speaker slip for you.
Pardon?
I need for you to fill out a speaker slip, please.
It's right to your left.
Right there.
There are no pins up here. Oh. I just don't have the case number on there.
Would you please state your name and your address, please?
My name is Robert Florence, and we own the adjacent house to them by frontage 2313 North Powhatan Street.
Thank you. Okay, go ahead.
This has come to my attention recently, so I felt I should come down and at least voice our opinion as to the addition that they've proposed. I broke it down into a couple things so you could see the issues pretty clearly as we would see them. Zoning, our house conforms. It's a 10-year-old home, and it conforms to the existing zoning for our house. They have a pipe stem lot, and that's a little bit different. Their deck that they had on the back of their house, as I recall, it had 4 trees that blocked their property side from ours, giving it some, let's call it screening between the 2 properties. Those trees are now gone from that property. For various reasons, they're gone. You can see 3 of the stumps, and 1 was enclosed in the deck, so that's number 4. So now, when you walk out, what we did on our side of the property, we put in a row of 7 evergreen trees. But it's my feeling that with the size of the addition and the going beyond the setbacks, that's going to be pretty imposing on our property, and that I'm just suggesting maybe there should be some more screening on their behalf, not on mine, but on theirs, to protect the values of the property. Second of all, this is something I really don't want to have to bring up, but I will bring it up. I have sensitive ears, and I wear headphones to protect my ears. And they have 2 big Labradors. Now, I love Labradors. I love dogs. We have a little dog, but they have big dogs. And if their dogs are not particularly tended to, they have an electric fence between their property and mine.
Just could you sum up, please?
Pardon?
Could you sum up, please?
Yeah, okay, so real quick. So I have sensitive ears, and I'm afraid that if they put a screen porch there, that you're going to get a little bit of a sound vortex between their place and our place, and dogs left out all the time. Maybe, maybe not. I don't know. That's hypothetical, but worth mentioning. Then there's always the fire issue, them getting closer to our property, and even one of their trees kind of blew over one storm and even hit our house. but that's nothing. And then the final point that I want to make is called external obsolescence. And when one extends property boundaries beyond, or the improvements that are being suggested, when they go beyond what the normal zoning is, that could create some obsolescence to neighboring properties in terms of the value that they would receive if they were ever sold. And I think that might be the case with this, especially because of that overhang is only like 4.7 now, and that even the 6 foot, they use the side yard of their house as a backyard, and that would then clinch that in their use of that space, and that's all I have to really say.
Thank you very much. Comments, questions, motions?
Madam Chair, I find the last speaker's issue somewhat compelling. And I don't know exactly how to proceed. I'd like to explore them more in terms of if there's remedies that he feels would be appropriate. He mentioned screening and noise and things like that, but I don't know how to do that at this point. And I don't know if others feel the same way, because one option would be to defer this matter, to give the applicant time to consult with his neighbor and see if they could work out a mutually acceptable solution on some of these issues.
Does staff have a comment on the last speaker in terms of encroachment, side yards as backyards, et cetera?
I think really the only difference in this case is we would be approving a roofed over structure. They now currently have a large deck that takes up the entire back of the home. I'm not sure how much of a difference this is really going to make. As to the screening, there is an easement along that right side property line, which makes it difficult for them to probably plant anything in that area. They may not be allowed to plant anything if the county says they can't.
Is it easement there?
Oh, that's that dotted red line.
So I guess our map doesn't show, and I have to admit that when I was on my walking tour this weekend, I did not walk down 22nd Street and 22nd Road to look at the comparisons that you had offered, and I probably should have done that. But I do note that, in fact, it looks like this house is on a double pipe stem lot, and then their neighbor is also on a pipe stem lot. And there are other pipe stem lots in various configurations I can see, but do you have any information as to whether or not any of the comparisons listed in page 2 of the staff report occur in the similar configuration where you have a backyard that's the legal side yard that's being used as a backyard, where the legal side yard is being used as the front door on a pipe stem lot? Are any of these comparable in that way?
I'm trying to think. I don't think any of those were. They were probably all interior lots. That does make it difficult for this property. The property owner who spoke before behind them is actually on a pipe stem, and we had to deal with the use permit with them to add a deck. They have completely different setback requirements, 25 feet on all sides compared to this, but these other properties I looked at, I think were all just normal interior lots, and most of them face the street, so there is a difference.
So I think I would like to get more information on a couple of fronts before I would feel comfortable voting one way or another, and I don't know what my colleagues want to do, but I also would be quite comfortable with the deferral to get more information.
Well, I think if there's a motion in that direction, there should also be direction in the motion as to the reason for the deferral. In other words, some of the issues that you've raised that you'd like addressed in the interim.
Madam Chair, I would
Mr. Smith.
just to clarify, there are two easements on the property. One is a sewer easement in front, and the one along the side is a 5-foot house connection easement.
I don't know what that is.
Can you explain that, Mr. Knoxon?
Usually those are for water or power. So they're typically private.
Going to the
And they
back.
could be public as well. The water one would be a public one.
Okay.
So, if I were to make a motion, the 2 points I would want more information about the issue that Mr. Owen raised in terms of precedent, because when we have much greater setbacks for backyard type uses than we do side uses. And so a little exploration of that question in terms of precedent. And then the other point I would make would have to do with the speaker who lives adjacent to this property having a conversation with the applicant to see if there's any mutually acceptable solutions here, or at least what the range of solutions might be. And if you wish, I'll turn that into a motion.
I think the comment about screening that he made has been addressed by the easement.
Well,
So
it's not clear if
his screening remains, but
And it's not clear if screening is not permitted in that easement area.
We'd have to find out who has authority over that easement, exactly.
okay, yes. Okay, proceed. Proceed.
Second.
Well, we need the case number and a few,
Okay, I will
not quite as loose as that.
move that this item be deferred at least 1 month. And it's case number V11160-16-UP-1 to gather additional information on the precedents for a side yard porch enclosure this close to
Pipe stems?
on a pipe stem. Information on what is what permissible uses in terms of screening are allowed in the setback area. And number 3, to allow the adjoining neighbor to consult with the applicant on possible solutions.
Could I suggest that while you're at it, we get the feedback from all the other neighbors that we don't have?
And yes, and to get written feedback on from the other neighbors.
And your date?
And I'd move to at least 1 month, but I guess I can move it. What do you think?
I mean, the public advertisement's not going to change, so they have pretty much an entire month to speak with the neighbors, obtain signatures, that such thing.
To the August 10th BZA hearing.
Would 1 month be sufficient time for staff to help us research the precedents?
That wouldn't take any time at all.
Second? Is there a second?
Second.
Been moved by Ms. Malice and seconded by Mr. Owen.
Just want to make sure the applicant
Yeah,
understands.
I was going to ask
Okay.
if the chair would make sure she understands that also. That was going to be good.
Is the motion clear to you?
Why don't you come up to the microphone so that this can be on the record?
I think some of the work is staff work in terms of precedent and pipe stems and what's permitted in the easement on your side. In other words, if screening. But the motion also encourages you to meet with your immediate neighbor who has objections and to get written feedback from all the other neighbors that apparently have spoken to you but have not provided us with any expressions of support or.
So do I need to get like a letter, or is just like a little petition type, sign off?
Either
yeah,
or-
we're
either
good to
or.
go kind of thing. Does it matter?
It doesn't. No, it doesn't.
Staff can help you with the form.
They can, yeah.
We get that in multiple different formats.
Okay, and the other comment I'd like to say, since he talked about the trees that got cut down that were on between our properties, At the time we purchased our property in 1999, there was a single Cape Cod in the middle of that large lot. And there was a old standalone garage that was very close to the property line. And in doing their construction work and building those two houses, particularly the one so close to ours that was already there, those trees needed to be addressed before that big house went in. So we had to do that at that time. So that's why the trees came out, because he was putting up two houses. If you want me to talk to him, I'm not sure that we'll ever come to an agreement, quite honestly.
Well, I think
So-
when you come back and you can report any progress or lack of progress, but you can reach out to your other neighbors.
Okay.
So that everyone's clear. We have that feedback at least, and
All right.
to which we will add the report of information from the staff.
All right.
And that's for August. Thank you.
I'm sorry, just one more question. So I think we're presuming that you would prefer to have your next hearing in August as opposed to, say, September. But if,
We're looking to just get this done. We were, as I said, we were pretty much just replacing a deck with a screen porch and patio, and the whole idea that we needed a use permit took us a little bit by surprise because, the structure's already there. We weren't really doing much different other than screen porch over, instead of a deck. So I didn't realize they were treated differently, and the angle of the property just. So yes, our contractor has been, waiting for us to get this done, and so I was hoping to be able to tell them tomorrow that we were approved, but I guess not. So yes,
if you preferred September, I think we would be happy to accommodate you, but you would prefer August.
Yes, because we have a series of home improvements that this has to be done first. The siding on the house, we're looking to make some improvements on our deferred maintenance. So
Okay.
we would like to get things going because we've got deposits and people ready to work.
Okay.
So,
Okay, thank you.
thanks.
Okay, all those in favor of the motion to defer for 1 month?
Aye.
Aye. Thank you. Next case, please.
This is V-11161-16-UP-1. This is a use permit request by Matthew Dodge and Eliza Tanaka Dodge to permit a setback of 14.8 feet from the 17th Street North right-of-way instead of 21 feet as required. This is for the reconstruction of an existing front stoop. It's in our 6th zoning district on a premises known as 4324 17th Street North.
Questions for staff? We hear from the applicant, please.
Good evening. My name is Matt Dodge. I'm the homeowner and applicant for this use permit. Essentially, the reason I applied for the use permit, it'll be clear if you look in the packet at the photos of my existing stone steps and stoop. They're crumbling, they're pulling away from the house. It's essentially created an unsafe situation for my family and other people who come up and down those steps to come into my house. And the damage to the steps is great enough that I need to just replace them. There aren't really repairs I can do to the steps. So I hired Bright Construction to replace the stoop and steps and applied for this permit. And through that process, I realized my existing stoop is not in compliance with current zoning laws. It's less than 21 feet away from the street. The new stoop I'd like to build to replace it essentially has the same footprint as the one it's replacing. My current stoop is 4 feet 9 inches wide. It's 4 feet 9 inches deep and 6 feet wide. The new one will be 5 feet wide and 6 inches deep, so essentially 3 inches deeper than the current stoop. Essentially, I want to try to address this unsafe situation at my home as soon as possible, so I ask your support of this use permit to let me replace the existing stoop and steps at my home. Stay for any questions.
Thank you. Questions?
You know, ordinarily, we would be quizzing you on if you have neighbor support on this. I think in this case might be overkill, but I assume your neighbors were notified of your action.
To be honest, this is the first time I've gone through this process, and I didn't realize written support from neighbors was part of it. I mean, I can say I have verbally spoken to them about the fact that my steps are crumbling and that I'm planning to do something to ameliorate the situation, and I haven't had anyone express objection to that proposal.
Okay, thank you. Any other questions? Motion?
Madam Chair,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V11161-16-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Aye.
Thank you.
Next case.
Okay, next case is V-11162-16-UP-1. This is a use permit request by Stephen and Rhiannon Lautner to permit a setback of 8.1 feet to the projecting bay and 9.6 feet to the wall of the home and rear porch from the left side property line instead of 10 feet as required. 3 feet to the bay window, 3.5 feet to the eave, 5 feet to the wall of the home from the right side property line instead of 8 feet as required. 2 feet to the air conditioning units from the right side property line instead of 5 feet as required. 8.5 feet to the stormwater planter box, 13 feet to the egress window well, 15.2 feet to the eave, and 16.7 feet to the wall of the home from the North Monroe Street right-of-way, and that's all instead of 25 feet as required. Then 2.4 feet to a stormwater planter box from the rear property line instead of 21 feet as required. This is all to permit a home with a height exceeding 2.5 stories within 25 feet of a street. Also for an aggregate side yard of 11.1 feet instead of 18 feet as required. This is for a new 3.5 story home with a double-decker rear porch, a front porch, right and left side projecting bays on the first floor level, a front egress window well, front stormwater planter, 2 right side air conditioning units, and a rear stormwater planter box. This is in the R5 zoning district on the premises known as 1413 North Monroe Street.
Questions for staff? Hearing none. We hear from the applicant, please.
Good evening, Madam Chair and members of the board. My name is Rhiannon Leutner, and I'm here this evening with my husband, Stephen Leutner, and some of our wonderful neighbors who've taken time away from their family to be with us tonight, so we're very grateful for that. We're the owners of 1413 North Monroe Street, and we'd first like to thank you all for your service to our community, as well as your time to hear our application tonight. We're also grateful to staff for helping guide us through the application process. We purchased our home in 2012 upon military transfer to the Pentagon, and over the past 4 years, we've built some amazing relationships and just really come to grow to love our neighborhood. As our sense of community has grown here, so too has our family, quickly outgrowing our World War II era small home. We also have plans to adopt a 4th child in the future, and so our home is getting quite small. My husband grew up in the local area, and so we've been familiar with the local Arlington neighborhood. He still has family here, so we're very excited to raise a family here. That's kind of been our dream, and we now have a permanent assignment here to the area, so we're hoping to move forward with new construction on our lot. The overall size and placement of our proposal is designed to fit in and complement with the diverse character of our neighborhood. You'll note in the plans submitted our desire to build a traditional Arlington bungalow-style home that we feel fits and complements the neighborhood as well as the greater Arlington area. This welcoming design will maximize our interactions with the community as well as the outdoors. Also notable, there's a distance of approximately 3 feet between our front property line and the North Monroe Street curb, effectively increasing the appearance of the front setback. For example, a 17-foot setback would appear to be set back 20 feet from the North Monroe Street curb. We highly value the opinion of our neighbors. They're the ones that have to look at this home every day. And given our plan to be here 30 plus years, we've gone to great efforts to continue to grow our relationships with each of our neighbors throughout this process. And we've sat down with all 15 of our neighbors to ensure that their considerations and opinions were factored into our designs. We've had many occasions to sit down on numerous times to continue to explain to them what we were trying to do and why we're even here tonight. And so we've specifically highlighted during those meetings what it is that we're here and the relief that we're asking from the board tonight. In fact, our neighbors to the right at 3519 14th Street recently provided a letter of support, and we have copies of that if you didn't receive it, addressing this right side bay window when it became clear that staff might not be able to support this request. Their letter describes an overall support for our project, as well as their specific desire to allow a reduced setback to the bay window on the right, that they think the county should support things like this that result in a more aesthetically pleasing and architecturally interesting home. This is the side of the home facing their property, and they feel it will provide a much nicer home for them to look at. We've read the staff recommendation and are grateful that they support the plan to build a house that's slightly wider and shallower than what we could otherwise build by right, allowing for us to preserve this large old-growth white oak tree in the rear of our property. There are essentially three items that staff did not recommend support for: the right side bay window, a home that exceeds 2.5 stories located less than 25 feet from the street, and placement of the air conditioning units. In the spirit of compromise, we've agreed to move the air conditioning units to a by right location and have copies of the updated plans to reflect this change. This leaves two remaining issues that we request support from the board for tonight. The first is the right side bay window at 4 feet and 3.2 feet to the eave. I might point out that's not 3 feet as advertised. Mr. Noxon informed me that that was, a different measure to account for the eave, but we would like to highlight that that is 4 feet to the bay, and they've recommended support for 3.5 to the eave of the house, so we feel that this is reasonable. And then the second issue is allowing a home that exceeds 2.5 stories to be built within 25 feet of the North Monroe Street right-of-way. And this will essentially have the exact same footprint, height, and look identical to what we could otherwise do as a 2.5-story home, which staff provided support for. I'm not going to go into great detail on each of these items right now, respecting my speaking time, but we're certainly prepared to speak to them as the board wishes to address them. In summary, we've tried to be reasonable with our request, and we worked very hard to reach consensus in the design process of our new home. We feel our proposal is compatible with the surrounding neighborhood and will not adversely affect the health and safety of any members in our area. We also think that it's not detrimental to the public welfare or injurious to property, and without exception, every neighbor that we've discussed this project with has offered enthusiastic support. So we respectfully request that the Board of Zoning Appeals adopt the alternative resolution approving the proposal as advertised without the right side relief for placement of air conditioning units.
Thank you. Ms. Malice.
Just want to clarify your proposal. You want to move the air conditioning unit to a by right location, is that correct?
Yes, ma'am.
And did you say you're also withdrawing the idea of the bay window?
No, ma'am. We'd like to request support for the right side bay window this evening, as well as to build a house that exceeds 2.5 stories.
And then could you clarify the argument that you made for the 2.5-story building?
If you'd like to go into that now, certainly.
Could you repeat your testimony? What you said that?
So essentially, it's not that simple, but what staff has supported is the placement of a 2.5-story building within the 25-foot setback.
Right.
And this gets into the difference between Arlington zoning ordinance and Virginia building code, which I think I'll let my husband speak to if...
Well, so your argument is
that... We would be able to build the exact... It's going to look identical, but Arlington zoning ordinance, because of the way that they define a basement being a little bit different from Virginia building code, would call it a 3.5-story house. What we would be building by code is a 2.5-story house per Virginia code. We've done many things which we can speak to try and get there, and we're still 6 to 12 inches short to try and reduce the basement height. But what we would do is dig deeper and deeper and deeper and add a bunch of stairs, but from the outside of the house as you pass by, it will look exactly the same.
So, thank you. Now I'd like to talk to staff about your point. So, could you comment on this argument that it's the basement height that's driving this?
That's correct. We have an ordinance, actually a definition of basement that states that it is a story if 50% of it is above grade. Okay. So if you were to sink the house down further into the ground, more than 50% would be below the average grade, therefore making it not a story anymore.
Okay. And what's the problem with doing that?
Ma'am, if I may address, my name is Steve Leutner. I'm Rhiannon's husband. The issue with sinking the basement down further is that we cannot we cannot lower the basement ceiling or the first floor anymore at this point. That is being driven primarily by the fact that we are trying to do a front-loading garage that has a reverse slope driveway located to it.
A design issue.
Correct, ma'am. We have lowered the garage as much as we can, and that's being driven by the fact that we need to passively drain the stormwater to the stormwater sewer on the west side of Monroe Street. We've set the basement level and, in fact, gone back and regraded it to the absolute lowest that we can get that. We've also gone through and lowered the garage ceiling height to as low as allowed by ordinance, which is 7 feet tall. And we have also gone back to the structural engineers and asked them to reduce the gap between the first floor and the ceiling height using reduced centers and more strengthened beams. So at this point, there's nothing more we can do to lower the basement ceiling or the first floor. The only way that we can comply with the Arlington County zoning ordinance to define this as a basement is to continue to dig down deeper underground. This will have some adverse effects on our utility of the building because it will require the addition of several more steps in the basement area that we specifically are designing to be used for live-in grandparents as they age out, and we have several small children, as we previously mentioned, making it less useful in that regard. It will also require us to add additional risers on the back of the house for the breezeway that goes from the basement level to grade, which will further impinge upon the root system of the tree that we're trying to preserve. This impingement would be about 3 to 4 feet, depending on how the math works out for how far we have to lower the basement.
So did you say it's the garage configuration that's your constraint?
Yes, ma'am, it is. We have designed a front-loading garage with a half-submerged garage that is about 2.5 to 3 feet below grade.
Okay. I have 2 speakers. Ashley Parrish, to be followed by Julie Bedford.
Madam Chair and members of the board, good evening. My name is Ashley Parrish. I live at 1416 North Monroe Street, which is just across the street from Steve and Rhiannon. My wife Janie and I and our 2 children have lived there for about 8 years. What I'd like to do is make 3 points this evening. First, we strongly support Steve and Rhiannon's request here. They've been wonderful neighbors. They've done a great job of keeping us informed of their plans throughout the process over a period of several months. They've solicited our input, and we've been grateful for that. We've looked closely at the design, and we think it's very much in keeping with both the street and will enhance the overall neighborhood. Second, I was pleased to see that the staff largely supports the request. I also support that and think the staff is quite correct to grant their request to preserve the old oak tree in the back, which I think is important to the neighborhood. And 3, let me just say a few things about the 2 issues you've been talking about. With respect to the 3.5-story versus 2.5-story, it's obviously complicated, but in my sort of lay view, it seems to me that that's a perfect example of a situation where the ordinance requirements in terms of their purpose and spirit have been fully satisfied, and it's one of those situations where the board should exercise its discretion. It is not going to change the way that the building looks. All it's going to do is, detract from the use of the building in a way that doesn't make a whole lot of sense. So certainly as one of their neighbors, we fully support the idea that it should be classified as 3.5 stories. With respect to the bay window, we have the same views as their neighbors who are directly impacted by that. I think as you start seeing the building spec homes that are often built in the neighborhoods, it's nice to have something that has more character to it. We've looked at the plans and we think that the addition to the bay window would be something that would be aesthetically pleasing, and as living just down and across the street, we'd be fully supportive of that. So thank you very much for your time this evening. We'd be grateful if you approved their request.
Thank you. Julie Bedford.
Hello, my name is Julie Bedford. I live at 1408 North Monroe Street in Arlington, basically right across the street from the Lutners. We've become great friends with them. I have a 6-year-old son who plays with their young children as well, and we've become quite close. I've personally been living in Arlington for 24 years, and I've seen a lot of development in the area, including our house, which is a new build as of about 9 years ago. And I fully agree with the proposal that Steve and Rhiannon have submitted, and very much believe that it's in line with our neighborhood feel, and it will fit right in and actually, help in raising the property value and aesthetics in the area. And again, I support Rhiannon and Steve's proposal wholeheartedly, and I'm glad, since I'm a biologist, very happy about the oak tree and trying to save and preserve that. Rhiannon and Steve have gone out of their way to make sure that we're very well informed along each step of the process of their putting forth their building plans, and I believe that their request through the county is reasonable, and I don't see any reason why the board would not want to approve their request. I understand that there have been some reservations about a couple of issues named. I think they've already been mentioned. I'll just reiterate them. The bayside window, I think that I fully support that and agree with what's already been stated. I'm minding my time here. And also with regard to the discrepancy between the 2.5 and the 3.5 story building, I agree with what others are saying in that aesthetically it won't look any different. I think they're just going to have to dig down deeper and to accommodate their growing family, especially if they're planning on adopting another child. I think it would be of use and wouldn't interfere with aesthetics or property or safety or any of those other kind of issues. And I encourage you to approve their proposal. Thank you very much.
Thank you.
Madam Chair, can I ask a question of the speaker that just spoke? Do you happen to know, do you happen to have had discussions with your neighbors to the extent that you happen to know whether or not their actual peak of roof would be above or below your peak of roof? That is the ultimate sort of altitude of their house?
I have not had that specific conversation, but I'm sure that we
My sense is that the land slopes slightly down in their direction was my recollection.
Yeah, I think if you brought up the picture of the aerial view, our house is directly
at the bottom.
At the bottom across.
So my sense is that the top of their roof, as proposed, would still be a little bit lower than your roof is. Okay, thank you.
Thank you.
Thank you. Any comments or questions? Deafening silence.
I guess I'll just add an additional comment that if you look at the photo that's in front of us right now, you'll see that every single house on the other side of the street is a relatively recent knockdown and rebuild, and they all appeared to me, I wasn't, measuring them with, but they were really big. And then there's some more of that in the upper left-hand corner. I don't remember the street names, but in the upper left-hand corner of the picture are some other really big, tall houses. And so My sense is, and furthermore, the applicants have been incredibly diligent in consulting with a wide swath of neighbors in the area. And so I think there's every reason to believe that on this part of the neighborhood that's nearer the park, that the trend is definitely in the direction of having super tall houses. So I feel like, to my mind, there's a little bit more. I would be inclined to be a little flexible on height for this particular parcel, because I think it's in keeping with many of their neighbors' rebuilt houses.
Madam Chair?
Ms. Malice.
The issue I'm working through is, often we're presented with a good reason that we should accommodate the change, and I'm not hearing that good reason. Seems like it's a design issue that they've gotten themselves into that has design solutions to get out of. Often the cases that we have are, have a little bit more of a problem that they're having difficulty solving. And so I'm mulling over whether there really is justification.
I would say one issue is the tree and the fact that they couldn't go back and get away from the setback and not have the same height restriction, perhaps.
Madam Chair.
But I understand your comment about the design. Yes, Mr.
I'm kind of where Ms. Malice is. I was listening for a reason that you can't go down another foot. You can't dig deeper another foot or so. And I didn't hear that because it's big. I mean, 3.5 is very big. 2.5 is big. And there are a lot of, it's a big structure. And there are, as Mr. Owen noted, a lot of new big structures across the street. 5 of them.
That may be conforming.
But they're not 3.5 stories. I don't think. So that's where I am. I don't have a problem with the rest of it. I appreciate the movement of the AC units, but the height is troubling.
I wonder if the applicants would like to make any further comment on the height issue.
Please, thank you. I guess one point we'd like to make is it's not height. So the 2.5-story house is the exact same height as the 3.5-story house that the staff will support. That's kind of our point. We're below the maximum height allowance, and we're also below the maximum footprint allowance. We could build this house by right and shove it back and kill the tree, and that's what we're trying to avoid doing. So we could certainly meet that 25-foot setback if we set the house back further and took the tree down, and that's what we're trying to avoid doing. And I could see why it's definitely complicated trying to figure out you must imagine how long it took us to wrap our head around, what do you mean 2.5 stories and 3.5 stories is exactly the same? But because of the way that Arlington zoning ordinance defines a basement and Virginia building code does, the height is not the issue. We're below the allowable max height, and we would be with a 2.5-story house or a 3.5-story house.
But the issue is that you're in the setback.
Mm-hmm. Yes, ma'am, understand. And we'd like to not go back to meet that setback so we don't have to kill the tree.
Right.
Right.
And make 2 brief points. In terms of the heights of the buildings across the street, I've got some pictures I can show you if you'd like. The 2 houses that you see in the bottom right-hand corner are 3-level houses plus a attic above them. The other houses I cannot speak to exactly, but they have a at-grade level garage with 2 stories above them.
We're proposing to drop our garage another 2.5 to 3 feet lower than that, and also the design of our house will actually slope away from the street, giving the appearance that it's not quite as imposing as the perpendicular facade of the homes across the street.
And can you speak to whether the houses across the street were built in the setback?
I think I understand your question, ma'am, and that's to deal with the property lines. There is approximately 3 feet between our property line and the Monroe Street curb.
No, I'm talking about across the street.
Okay.
Did they encroach in the setback?
They did not encroach on the setback from their property line. However, they have a sidewalk that is entirely on their property, approximately 6 to 7 feet. So if you consider their distance from the sidewalk to their house, it is approximately 18 feet.
From the sidewalk, which is the public right-of-way, which is what we're trying to compare apples and.
I've got a GIS map too. I can show you that if you'd like.
This, and the Arlington zoning ordinance, as we understand, was changed somewhere around 2012. Mr. Knox could probably speak to that. And so the classification of the homes across the street might be a little bit different by today's standards. But from an outsider's perspective, just as you view them, our home would be no different, and we would argue that it actually would be more aesthetically pleasing as it would slope away from the street, have a large inviting front porch, which is not present on the other homes, and our garage would be at a lower grade than their homes would be, so that would be a less imposing view to the neighborhood. So
we would ask that if you grant us the 3.5 story, that you impose upon us the restriction that we meet the Virginia Building Code standard of a basement.
So that ensures you that we do, in fact, drop the garage, and so it's almost a conditional approval, if you will.
Can't do that. Somebody should just make a motion and see where we are.
Okay. Motion?
So I'll make a motion.
Okay. Turn your mic on. Thank you.
Okay. All right. In case V 1116216 UP1, I'd like to make a motion that the Board of Zoning Appeals adopt the alternative resolution. In other words, as advertised, with the conditions as listed.
I'll second the motion.
It's been moved by Mr. Melnick and seconded by Mr. Owen. Discussion?
I'd like to offer an amendment to address the fact that the applicants have acquiesced on the air conditioning location. If we adopt the alternative resolution, would we need to modify that to make sure that the air conditioner is not where staff didn't want it?
We would remove the request for 2 feet to the air conditioning units from the alternative resolution.
I would move to strike the 2 feet to the air conditioning units from the motion.
Is that acceptable, Mr. Melnick?
Yeah, I'm fine with that.
Okay.
I think.
Mr. Owen?
Well, I would ask unanimous consent to make that request.
Got it.
Okay. Unanimous consent? Yes, it appears we have unanimous consent to strike the air conditioning units.
And then I don't think I understand this holding you to the building code thing, whether that gets us anywhere or not.
I guess what my husband is trying to convey, that we don't plan to leave here and then go redesign our home to make it larger. We're going to keep it low, and it's really close to being 2.5 already. So we wanted to have you feel good about it.
If whatever comes out of this hearing, you're bound by what you submitted.
Sure.
So you couldn't do that.
Elevations, ma'am, are not part of that. So certainly we would be required to be lower than the maximum height requirement, and that's always our intent, and we would meet that.
Sorry?
We are not adopting a height at this time?
Not a height issue in stories.
What happens is usually when you approve these use permits, you're approving it based on the plans submitted. So they shouldn't show plans that say that it's going to be a foot higher than what they're showing on these plans, or any higher, or any wider, longer.
So these plans do address the actual height that this building
They do,
has.
that's correct.
That was my question.
And would that include then the handout that we just received?
Yes.
Okay. Any other discussion? We have a motion to approve the alternative resolution in which the air conditioners have been stricken. All those in favor?
Aye.
Opposed?
Nay.
3-2. Approved 3-2. Thank you. Last case.
The last case tonight is V-11163-16-UP-1. This is a use permit request by 1404 North Hancock Street Investment, LLC, to permit a setback of 2.6 feet to the eave and wing wall of a second-story addition, 17.8 feet to the rear deck, 23 feet to the second-story front addition, 23 feet to a new two-story rear addition, 15.7 feet to the eave, and 16 feet to the wall of a new detached garage from the 13th Street North right-of-way instead of 25 feet as required. 7 feet to the air conditioning units from the 13th Street North right-of-way instead of 8 feet as required. 5.3 feet to the eave and 5.6 feet to the wall of the detached garage from the rear property line instead of 10 feet as required. 3.1 feet to the egress window well, 4.8 feet to the eave and 5.3 feet to the porch base, 5 feet to the wing wall, and 6.1 feet to the wall of the two-story rear addition from the right side property line instead of 8 feet as required. This is all for the construction of a new eave overhang for a new second-story addition above the existing first-floor walls, new right and left side wing walls, a new second-story front addition above a new front porch, a new rear deck, a new detached rear garage, a new right side egress window well, a new front porch, and a new two-story rear addition. This is in the R6 zoning district, premises known as 1404 North Hancock Street.
Questions for staff?
Madam Chair?
Mr. Owen.
Yes, I'm a little confused in the staff recommendation. Line 4 seems to suggest that the staff recommendation is to deny a setback of 5.7 feet to the eave and 16 feet to the wall of the detached garage. But 4 lines down, it suggests approval of 15.7 feet to the eave and 16 feet to the wall of the new detached garage. So, from 13th Street North in both cases. So, here, I'll show you on mine.
Sure.
So I'm just a little bit confused about what the recommendation actually is with respect to that aspect.
The recommendation would be to provide at least 18 feet from the wall of the garage from the right-of-way along 13th Street North. So that's what it should be. We're okay with the rear setback being about 5.7 feet. That's not an issue to us.
Okay, so it sounds like maybe the recommendation, the second rendition in the recommendation is surplusage and not correct. But the first one recommending denial is.
Make sure it's correct.
Actually, I'm happy to let staff ruminate on that while we proceed. They can give me an answer later.
Can we hear from the applicant, please?
First, I'd like to say thank you to staff, obviously, for all their hard work, and also to the board. I'm
Sir,
sure you all. Yes.
Could you identify yourself, please?
Oh, I'm sorry. Brian Normile. I'm the owner of 1404 North Hartford Street Investment, as well as the owner of the adjoining property, 1408 North Hancock Street. I'd like to thank staff and also the board for being here tonight to hear the case. To Mr. Owen's point, we appreciate, obviously, staff has looked at this project. You can see from the existing dwelling, this is a property where I acquired this property as well as the adjoining one on March 29th of this year. In each case, these properties were in significant disrepair. I've been working with the code enforcement department because each of them were at the point where the property at 1408 that I acquired was on the verge of being condemned. It was a hoarder property. And this property at 1404 is a situation where it's in significant disrepair. There's been a tenant in the property for 29 years, and no maintenance done over the course of that time, other than as done by the tenant. My request to redevelop this property, for the predominant nature of the request, is essentially to do things that fall within by right development on this property. We appreciate staff support on a number of the issues here, and it seems that I came up with the same question as I reviewed staff recommendation in the last day with Mr. Owen, as it relates to the placement of the rear garage. I think it's important for staff and for the board to understand the existing garage situation, and previously we had that up there. This is a property that actually has a garage that's attached to the property at 1408 that currently sits grossly non-conforming, and it's something that I intend to demolish. And if you can see it from your report, that's really the crux of the issue. It appears that staff supports the project as a whole, subject to a couple of amendments being made, which we share. We've had the opportunity to review staff's recommendations, and we share them and have actually come up with a solution to them. It appears that the three requests from staff would be to essentially comply with the air conditioning placement on our site plan, which we are able to very easily move forward so that they comply with the 8-foot side setback. So that's one which we can easily comply with. Two, staff has asked that we address the egress window well, and we've looked at our plans and come up with a plan to essentially put the window well at the rear bump out, so where it would be compliant by code. So if you look at the plans in your set of the existing footprint and the rear appendage, that's essentially a breakfast room now, we can come up with a way to put egress where it would, in essence, not be a zoning violation. So those two issues we have no problem complying with and want to, as a report, as a resolution to staff recommendation. We would look for your guidance as it relates to the issue of placement of garage. Essentially, as I understand, the garage should sit in the rear of the property 10 feet from the rear property line. The property currently abuts the Clarendon Baptist Daycare. So there is no, it's essentially the playground. There is no rear dwelling that abuts this property where the garage sits. What we've requested as a part of our application is to essentially sit 5.6 feet to the rear property line in lieu of the 10, which is existing. And part of that request is because we'd like, from an aesthetic standpoint, to keep the garage a little bit further from the house. Staff has requested that we keep 18 feet from the existing property line. We're happy to discuss that as a part of this request, but we would ask that because of the existing nature of the current garage being absolutely non-compliant and in adjoining with the adjoining property, it's essentially a dual garage between this and the neighboring property. We would ask that the Board of Zoning Appeals look favorably upon our request, but we're happy to discuss it tonight. And as it relates to support of the project, the Baptist Church behind me, I've worked with them in the past on other projects, and I am the adjoining property owner who would be most impacted by this project. And the only places where we've asked for any relief are really impacted most by me as the adjoining property owner. Thank you very much for your time.
Okay, questions of the applicant? No, I don't have any speakers.
Well,
Mr. Owen.
I did not see any neighbor outreach on this one. Is there a reason for that?
I felt as the adjoining property owner that I was the most impacted person by my request. I'd be more than happy to reach out to the neighbors, but I'm also developing other properties on the street and have a very favorable relationship with my neighbors on the street.
Do we have any speakers tonight? No. So this neighborhood is well known for its intense scrutiny of this kind of thing. And so I'm a little surprised that we haven't heard one way or another from folks. And I certainly concede that that as you are your own next door neighbor. But I think it would be comforting to have a little more evidence that, your neighbor across the street or, that others who could see or frequently interact with the property. And frankly, the church, I mean, even though it's an institution, I think it would be comforting to hear from them and say, our playground is here and this is how we feel we'd be affected by this development. It doesn't mean that you're doing anything wrong, but as you heard earlier in the hearing, sometimes we can be surprised by what neighbors have to say if they haven't had outreach, and that's not helpful to us. So, so that for me, that would be an open question: is have the neighbors identified any issues that that they would want you or us to consider?
Yeah, I think I would agree. I think that this neighborhood in particular is very activist, and you may know this already. You may have run into them. It's summertime. Sometimes that makes it a little difficult to do that, but I do think that you'd benefit from reaching out to the Civic Association and getting their feedback.
May I address your comments?
Certainly.
Just briefly. This is a neighborhood where I was a resident for 13 years. I lived on the adjoining street. I'm currently developing another new home 3 doors down from here. And with all due respect, I've built 50 projects in Lyon Village alone. I know Martha Moore and Bill Gerhardt, and I've worked successfully with them many times. I'm the owner of Liberty Tavern and other businesses in Clarendon. I understand this market, and I understand my neighborhood, and I understand what I'm doing. So I would ask, with respect to that, that if there were definitive issues with my project, this room could potentially in Lyon Village be full. We all know that.
Yes.
Everyone would be here.
But you're making the point, because if in fact that is the case, it wouldn't be difficult to get a letter from the association or an email or anything that just reassures us that it's not a problem, or at least gives other people opportunity to react.
In response to that, the process in Arlington whereby things are announced to the public and on the property at 1404, there's currently placards that have been placed on that property, on the posts, and as you said, with all due respect, Lyon Village is a neighborhood where your neighbors, as you said, this is your concern, and you don't want to push something through when the neighbors can't speak. But the reality is, the neighbors know. They've received notes. This is not a situation where they don't know the process. If this were a concern that was relevant enough to them, I think they'd be here. They've been here. The Board of Zoning Appeals has hearings 11 times a year. They would be here. It's not just that it's the summer.
All right. Any other? Yes, Mr. Smith.
And I want to say that you said he's making your point. I agree. He's making your point again. And it seems like the kind of thing that you would just say, well, sure, no problem, and get that done. I mean, because I can't imagine that, unlike a deck, you need this approved right now to get going so that you can have your party on it. I know you'd like to, and I can assume there's financing involved, but that a month for acknowledgement that they do know that you, as an outstanding member of the community, are doing this to relieve them of these eyesores would be kind of an easy thing to do.
I also have a substantive question I'd like to ask.
Mr. Owen.
So the staff report discusses a relationship between the garage location and the sidewalk passage that I don't think I get. I don't understand what the relationship is, and I'm wondering if you could describe that, please.
The idea of requesting that they move it back to 18 feet is so that they have a conforming parking space, 18 feet wide by 8.5 feet wide, 18 feet deep by 8.5 feet wide. And that partially is so that a car can park there and fit. and not be hanging out into the sidewalk. We have a big problem in this county with people parking out into the sidewalks, and DES goes out and violates people for that. And this is a very busy sidewalk, as you all know. People going between the parks, between the church. So we'd like to keep that free and clear of any obstructions to pedestrian activity.
And so, but I guess what's confusing me, if you could go to the aerial photograph, maybe, one of the aerial photographs. Yes. So my understanding is that we're thinking of moving this garage to various places in the backyard behind the structure. And you can see the photo of a car in that, at least maybe it's the adjacent driveway, right? And it looks like there's tons of room for a car.
But as the garage goes to the rear property line, the yard narrows. So the point is that if it's in the back corner, there's not enough driveway. It's fine if the car's in the garage. If it's not in the garage, it's going to hang over.
That's what I don't understand. Is that because it can't park next to the house? Is that the issue? I mean, it just seems like there's the entire length of the house plus much of the length of the front yard.
Extend all the way back?
That driveway is not going to be on this property anymore. They're going to put it back in that.
Oh, they want to swing it around. Oh, okay. I had misread the diagram.
The reason for that is because the existing location of that house doesn't allow you to even go down that side. Right.
Yep. I see. Yes.
So we would have placed the garage differently.
I see.
But you cannot go on the right side of the property because of the property line.
Yeah, so you're adding a curb cut. And
which, if you notice the property behind me, the same exact situation was done on the church property where those cars are shown.
Yeah, to me that just suggests even more, if you have a curb cut, then that's affecting lots of people who aren't even living right there. That's affecting anyone who's walking there. So, not that I think it's something that offends me necessarily, although I'm not a big fan of curb cuts, but it looks like you're subtracting one and adding one, so that's a wash. But I would want to hear from someone. Actually, this is a question for staff. I would be interested to know if Arlington County had any opinion about which of those two sidewalks is more heavily traveled. And maybe they don't, but if they did, I would want to know it. And potentially, I would also want to know neighbors' views on that.
Okay, any other comments?
Could I address that for one,
Sure.
Just one quick second?
Yes.
We looked at the opportunity. Essentially, what exists between 1404 and 1408 is a single curb cut for this property.
Right.
And we didn't have any way to provide off-street parking on Hancock Street because of existing utilities that were there in the front. So we really were left with a situation where the curb cut off of 13th was predicated because the ability to put something on the front because of utility poles doesn't exist. So this was a scenario where there really wasn't a lot of choice.
Is it your intention to get rid of the curb cut on Hancock and have a level sidewalk in that location?
Yeah, what I'd like to do is remove the curb cut, which is currently a double curb cut, that works for both of the properties, because as you've seen, that garage is shared.
Yeah.
There's no way to go down the property at 1404. That's the reason why we've looked to be able to provide an alternative parking solution here.
But if you look on this photo, what I'm asking is, when you finish, sometimes people do the development, right, and then the ancient curb cut that doesn't even connect to a driveway stays. And so what I'm wondering is it your intention to sort of leave that the way it is, or to replace it with a curb?
My intention is to remove the existing double driveway, put a new curb cut, which effectively will be for 1408 Hancock, the adjoining property, continue the sidewalk to the corner, and move the parking around the other side. So it ends up being a more aesthetically pleasing project.
In the end, would there be a curb in the location we're saying?
Curb. So everything that you see there is removed.
Yeah.
Curb would continue all the way from, essentially you're looking at the edge of 1408 Hancock in this drawing. It would go all the way down and remove all this concrete. So you'd have sidewalk, curb, and then grass strip.
Thank you.
So the ultimate improvement is much better than what you see.
Thanks.
So going back to Mr. Owen's original question, or about the length of what's left and why it has, I'm a little confused now about what length we were talking about that was going to hang out into the sidewalk. I guess that's a question for Drew. Mr. Knoxon. I'm a little confused about.
We're talking about the distance between the front of the proposed garage and
Proposed garage.
the property line
At the
and
old
how close
garage.
it would be to the sidewalk, exactly.
Proposed garage. And what's that distance there?
They're asking for, what is it, 15, let me find it real quick.
From off of,
15.7 feet to the eave. It's really 16 feet to the wall of the structure.
and that's tight for a car.
A required parking space is 18 feet deep, and that's what we're asking for them to give us.
Which means you have to move the garage.
Where? Oh, up forward. Yeah, towards the
Which
house.
we've looked at and explored, and we're happy to move the garage toward the house. It would essentially have us at, is it 14.7 feet, Sajid?
The rear setback to the building will be 14.3 feet if we maintain the 18 feet from the 13th Street to the new front of the garage.
So
essentially,
From the back of the sidewalk,
correct.
back of the sidewalk, to the garage front, face. Okay.
For the record, that was June Lee, the architect, I presume.
Okay. Right. Okay. How we going? More questions? What is your pleasure?
Could I enter one thing quickly? I just would request that the board understand and exist here that the staff is very familiar with the conditions on this property, and with respect to making the amendments that staff requests, owner is willing to make the changes to become in accordance with all of staff's requests, and would ask that you hear this tonight and vote favorably upon our application, subject to moving the air conditioning units, the window well, so it becomes compliant, and removing the garage to 14.3 feet from the rear property line this evening. Thank you very much for your time.
Thank you. Okay. What's your pleasure?
Well, Madam Chair, I would move the board to adopt a resolution accommodating the amendments that the applicant just indicated he was willing to make. And I guess that's merged with kind of an alternative, well, with the staff recommendation.
Okay. Is there a second to the?
But
Oh.
No, I just wanted it to be repeated to me to clarify exactly what those things are.
Oh, let's see if there's a second
AC
first.
unit, the window well, and the
Movement of the garage.
movement of the garage closer to the
House. Is there a second to this motion?
I'll second.
So, Mr. Smith has moved. Mr. Melnick has seconded the staff report with the changes to which the applicant has agreed. Discussion.
I have a question for staff. Does simply denying those aspects that you recommended denying cause the reverse to happen?
Denial of the window well and denial of the AC units will not cause any issues, but if you deny the garage in its current location, they don't get anything. They have to move it till it's completely compliant. 25 from the street, I find that impossible.
that motion would, in order to be helpful to the applicant, would have to be modified.
Well, the resolution as proposed by staff would be exactly what he's talking about doing, removing the AC units, the window well, moving the garage until it's 18 feet away from the street.
Resolution does.
Exactly.
Location
It does.
to move it to. Okay.
If you look at the actual resolution, it's not the one that Mr. Owen was talking about on the recommendation, but the actual resolution is correct, stating the 18 feet to the wall of the garage.
Okay.
Is that on?
It's on page 6 of the staff reports, the staff recommendation.
Any further comments?
I'm having a gut check right now on neighborhood notification, and I'm just, a gut check.
I think to me I'm sorry.
I was just going to say, Drew, can you tell us about neighborhood notification? How widespread it is? I mean, I know that signs go up. There are signs in every block in Arlington for something.
Goes into the newspaper a month ahead of time. Notifications usually go out to mostly the adjoining across the street behind neighbors, so anybody who is basically in view of the subject property is going to get a notification by mail.
Not civic associations.
We actually send them out to civic associations too. We send a preliminary notice out to them actually a lot earlier than the actual public notice.
Okay, that works for me.
Usually we don't hear much from civic associations in general. I mean, only a few have responded. They usually don't get into smaller residential properties.
It's not a civic association in general.
So I'm sorry, if I may. So my issue is that to move the curb cut to me in this location is a big deal. This parcel abuts a lot of non-residential property. It's one block from a metro station. And the pedestrian experience in this location is of much greater importance than it is in a typical R6. This is R6, right? R6 zone and parcel. And so my reason for not feeling comfortable moving forward tonight is mainly for that reason. I would want to have a lot more information from staff, leaving aside citizens, but from staff, I would want to have more analysis of whether or not they're comfortable with the treatment and the protections given to the pedestrian experience in this location. So I will not be supporting the motion for that reason, although I would support a deferral if that were up, because I don't think this is necessarily a bad project. I just don't feel I have the information to make a decision.
Okay, thank you. Any other comments? Question? Ready for a vote?
Might the applicant make one quick comment before we finish?
15 seconds.
That's all I need, not to be a pain in the butt. If you look carefully at this project, the curb cut that I request, I've spoken with Arlington County staff. It can be approved. The same curb cut abuts the property. And if we were able to look one street west, I used to live next to the corner that you can see in the corner here, and a curb cut was just granted off 13th Street while I lived there. It's accepted. It's happening. I'm not the first person to ask this, and I don't have the ability to put a curb cut off of Hancock Street. It's impossible.
Okay.
So
Beep.
I'm stuck.
Your time is up.
Done.
Thank you.
Thank you.
All right, it's been moved and seconded to approve the staff recommendation with changes from the advertisement to which the applicant has agreed. All those in favor?
Aye.
Aye. Opposed?
No.
3-2.
Does that mean approved?
Yes. Majority wins.
Thank you. The last case. Could you please address the minutes from last meeting, of which we have at least two sets?
You have a new set of minutes. Mr. Owen was nice enough to point out what he thought was exactly what happened, and from as many times as I've listened to it, I'm not sure if you all have had the chance to listen to the recording. We think that is what was correctly said at the hearing, between 6 different amendments or 6 different motions. I'm not sure if you all would like to defer it another month and just have a listen to the recording to see if you all agree or not.
I wasn't here, I'm not listening.
You get out of this.
I get out of it. I'm sorry for that. I apologize for that too, but.
I am still curious about Mr. Melnick's motion in number 3, where except without the sunset provision. I'm not sure what that was referring to. Maybe that doesn't matter, but I didn't really have unless that's referring to the requirement to maintain the ramp and elevator. Is that correct?
Yeah, if I can clarify, that's what it was.
Okay.
I didn't think there ought to be a provision that would invalidate it, causing them to have to rip up the driveway and that sort of thing. That said that the ramp was the sunset provision I was referring to. At least conditioning on it.
Okay, if you're satisfied that that's what was your intent?
Okay.
So I'm trying to find
Motion.
it, actually.
It's motion number 3 at the bottom of the second page. So, nope, wrong version.
The new version.
It's the new version that we got.
Okay.
So it's here. That's what you said, and then we've been wondering what you meant, and I think that you've clarified it now in tonight's record, and the question is, should the minutes be adjusted in some way to better alert history about what you really meant?
Yeah. So I think
You really can't change the motion, but can you add some clarifying language in the minutes?
I was referring to item 5 in Ms. Malice's motion number 2. The sunset provision referred to item number 5.
I wonder if it would be helpful for the purposes of the minutes for us to amend the minutes with a bracket, right? So that we're not claiming that it's what happened, but we're explaining it post hoc. So I move to adopt the minutes as proposed, with the revisions proposed and passed out tonight. I move that.
Second.
Okay, and then I ask unanimous consent after the quotation on motion number 3 for item 11090, that we add a bracket before the end of the quotation that says, i.e., condition number 5.
In motion number 2.
Right, from motion number 2, close bracket.
Okay. Unanimous consent. We all agree to that.
Did you say IE?
I.e., id est.
In other words. Hearing officers are admonished to use plain language these days.
Yeah. Is this discussion?
Sure, go ahead.
I think I'd be happy without the IE, just in parentheses,
It's fine.
item number 5.
That's fine.
Okay.
Okay.
That's good.
It's just-
Unanimous consent.
Do you feel clear this time on what our motion is?
At the bracket.
Bracket condition number 5, close bracket.
Can we so vote, or do we need to wait till next time when you give us a clean copy?
We're going to add that we're going to add that language in the brackets?
Yes.
Or- okay.
Okay, voting as amended. All those in favor?
Aye.
Mr. Smith abstains
Yeah, I abstain.
due to his
Absence.
absence,
No personal
his unwillingness to show up and break the tie that we have
I move
here
to adjourn.
and on the Supreme
Yeah,
Court.
I'm sorry. I see what problem that proposed an even number.
Okay, let's go.
I move to adjourn.
Smith? Okay.
I'll second.
Adjourn.
All those in favor of adjournment? Yay.
What time is it? Anybody know what time it is? 10? Yes. Close enough. 10:20.
It's a little longer than I thought it would.
Yeah.
Yes, considering.
Turn my phone off. Oh, there we go. He finally closed out of that. Yeah, that's close enough to 10:26.
You mean the 3 twos?